This study note includes 1.1 Essential elements of a contract, offer and acceptance. 1.2 Void and voidable agreements. 1.3 Consideration. 1.4 Legality of object. 1.5 E-contracts. 1.6 Constraints to enforce contractual obligations. 1.7 Quasi-contracts, contingent contracts, termination or discharge of contracts. 1.8 Special contracts, indemnity and guarantee, bailment and pledge, laws of agency. Study Note 1. Indian Contract ACT 1872. 1.1 Essential elements of a contract, offer and acceptance. Introduction. The law relating to contracts in India is contained in Indian Contract ACT 1872. The Act was passed by British India and is based on the principles of English common law. It extends to the whole of India. It determines the circumstances in which promises made by the parties to a contract shall be legally binding on them. All of us enter into a number of contracts every day, knowingly or unknowingly. Each contract creates some rights and duties on the contracting parties. Hence, this legislation, Indian Contract Act of 1872, being of skeletal nature, deals with the enforcement of these rights and duties on the parties in India. Commencement of Act. The Act came into effect from 1st September 1872 and applies to all contracts in India. Proposal. According to Section 2A of Act, when one person signifies to another his willingness to do or to abstain from doing anything, with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Acceptance. As per Section 2B, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Section 2C defines that the person making the proposal is called the promiser, and the person accepting the proposal is called the promisee. Agreement. According to Section 2E, every promise and every set of promises, forming the consideration for each other, is an agreement. As per Section 2F, promises which form the consideration or part of the consideration for each other are called reciprocal promises. Void agreement. According to Section 2G, an agreement not enforceable by law is said to be void. 2. Contract. Section 2H defines the term contract as an agreement enforceable by law. As per Section 2J, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Voidable contract. Section 2I defines a voidable contract as an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others. Essentials of a valid contract. Section 10 provides that all agreements are contracts if they are made by the free consent of parties competent to contract, for a lawful consideration and with a lawful object, and are not otherwise expressly declared to be void. The following are the requirements for a valid contract. Times there shall be an offer or proposal by one party, and acceptance of the proposal by the other party, which results in an agreement. Times there shall be an intention to create legal relations or an intent to legal consequences. Times the agreement shall be supported by lawful consideration. Times the parties to the contract shall be competent to contract. Times there shall be free consent between the parties to the contract. Times the object and consideration of the contract shall be legal, and the same shall not be opposed to public policy. Times the terms of the consent shall be certain. Times the agreement is capable of being performed, i.e., it is not impossible of being performed. Offer and acceptance. Offer. The term proposal is otherwise called as offer. An offer is a proposal by one person, whereby he expresses his willingness to enter into a contractual obligation in return for promise, act or forbearance. Section 2A of the Act defines proposal or offer as when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence. The person making the proposal is called as offerer or proposer, and the person the proposal is made is called as offeree. The offer must be a valid one. The following points are to be taken into account for a valid offer. Times the offer must be in clear, definite, complete and final in terms. It should not be vague in terms. Times the offer must be communicated to the offeree. The offer becomes effective only when it has been communicated to the offeree so as to give him an opportunity to accept or reject the offer. Times the communication may be in writing or oral. Times the communication may be in expressed terms or in implied terms. Times the offer may be general or specific. If an offer is made to a specific person, it is called specific offer. Such offer can be accepted by such specific person. If an offer is made to the world at large, it is a general offer. It can be accepted by any member of the general public by fulfilling the condition laid down in the offer. The Institute of Cost Accountants of India. Laws and Ethics. 3. Times communication of offer is complete when it comes to the knowledge of the person to whom it is made. Section 4. An offer which has been communicated properly continues as such until it lapses or revoked by the offerer or rejected or accepted by the offeree. An ideal offer should have all the essentials of a valid contract, as once it is accepted by the offeree, it becomes a contract. Revocation of offer. Section 5 provides that a proposal may be revoked at any time before the communication of acceptance is complete as against the proposer, but not afterwards. Example, a proposes, by a letter sent by post, to sell his house to B. B accepts the proposal by a letter sent by post. A may revoke his proposal at any time before or at the moment when B posts his letter of acceptance, but not afterwards. Section 4 provides that the communication of a revocation is complete. Times as against the person who makes it. When it is put into a course of transmission to the person to whom it is made, so as to be out of the power of the person who makes it. Times as against the person to whom it is made, when it comes to his knowledge. Example, A revokes his proposal by telegram. The revocation is complete as against A when the telegram is dispatched. It is complete as against B when B receives it. As per Section 6, a proposal is revoked. 1. By the communication of notice of revocation by the proposer to the other party. 2. By the lapse of the time prescribed in such proposal for its acceptance, or, if no time is so prescribed, by the lapse of a reasonable time, without communication of the acceptance. 3. By the failure of the acceptor to fulfill a condition precedent to acceptance, or 4. By the death or insanity of the proposer. If the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. A proposal also stands revoked if times it is not accepted in the prescribed mode, and if no mode is prescribed, in some usual and reasonable manner, or times the offered makes a counter-offer. Acceptance to constitute a promise, the intention of the parties must be communicated. One cannot accept an offer which had not been communicated to him. In general, uncommunicated offer cannot result in a promise. The term acceptance means admitting and agreeing to something, to accede to something, or to accept something. An offer to enter into legal relations, upon definite terms, to create legal relations, must be followed by an intention of the offeree to accept that offer. In Thavardar Perumal v. Union of India, AIR 1955 SC 468, the Supreme Court held that before an offer can become a binding promise and result in an agreement, it must be accepted, either by words or acts. A person cannot be bound by a one-sided offer, which is never accepted, particularly when the parties intended that the contract should be reduced in writing. A promise cannot bind its make unless the promise has assented to it. Section 4 provides that the communication of an acceptance is complete times as against the proposer, when it is put in a course of transmission to him, so as to be out of the power of the acceptor. Times as against the acceptor, when it comes to the knowledge of the proposer. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 4. Times acceptance may be oral or in writing. Times it may be expressed or implied. If a particular method of acceptance is prescribed, the offer must be accepted in the prescribed manner. Times. The conditional acceptance will amount to rejection of offer. A counter offer for acceptance will also amount to reject of offer, but the counter offer may be accepted or rejected by the other party. Times communication. Times mere silence on the part of the offeree does not amount to acceptance. Times. If considerations and objects are unlawful in part, Section 24, times agreements without consideration, Section 25, times agreement in restraint of marriage, Section 26, times agreement in restraint of trade, Section 27, times agreements in restraint of legal proceedings, Section 28. Example: A proposes, by letter, to sell a house to B at a certain price. B accepts A's proposal by a letter sent by post. The communication of the acceptance is complete, as against A when the letter is posted, and as against B, when the letter is received by A. The following points shall be taken into account in the case of acceptance. Times. And before he offer lapses or is revoked. Revocation of acceptance. Section 5 provides that an acceptance may be revoked at any time before the communication of acceptance is complete as against the acceptor, but not afterwards. Example: A proposes, by a letter sent by post, to sell his house to B. B accepts the proposal by a letter sent by post. B may revoke his acceptance at any time before or at the moment when the letter communication it reaches A, but not afterwards. Section 4 provides that the communication of a revocation is complete as against the person who makes it, when it is put into a course of transmission to the person to whom it is made, so as to be out of the power of the person who makes it, and as against the person to whom it is made, when it comes to his knowledge. Example: B revokes his acceptance by telegram. B's revocation is complete as against B when the telegram is dispatched, and as against A when it reaches him. 1.2 Void and voidable agreements. Void agreement. The following agreements are considered to be void. Times. The Institute of Cost Accountants of India. Laws and Ethics. 5. Times agreements void for uncertainty. Section 29. Times agreements by way of wager. Section 30. Considerations and objects unlawful in part. Section 24 provides that if any part of a single consideration for one or more objects, or any one or any part of any one of several considerations for a single object is unlawful, the agreement is void. Example: A promises to superintend, on behalf of B, a legal manufacture of indigo and an illegal traffic in other articles. B promises to pay to a salary of 10,000 a year. The agreement is void, the object of A's promise, and the consideration for B's promise, being in part unlawful. This section has no application to a contract, which is a single contract, and has no contingent part. Agreement without consideration. Section 25 provides that an agreement made without consideration is void unless 1. It is in writing and registered. it is expressed in writing and registered under the law for the time being in force for the registration of documents and is made on account of natural love and affection between parties standing in a near relation to each other, or unless 2. If is a promise to compensate for something done, it is a promise to compensate, wholly or in part, a person who has already voluntarily done something for the promiser, or something which the promiser was legally compellable to do, or unless 3. It is a promise to pay a debt, barred by limitation law. It is a promise, made in writing and signed by the person to be charged herewith, or by his agent generally or specially authorized in that behalf, to pay wholly or in part a debt, of which the creditor might have enforced payment, but for the law for the limitation of suits. In any of these cases, such an agreement is a contract. Explanation 1. To this section provides that nothing in this section shall affect the validity, as between the donor and done of any gift actually made. Explanation 2. To this section provides that an agreement to which the consent of the promiser is freely given is not void merely because the consideration is inadequate, but the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promiser was freely given. Examples: times a promises for no consideration to give B1 000 dash. This is a void agreement. Times A, for the natural love and affection, promises to give his son B1 000 dash. A put his promise to be into writing and registers it. This is a contract. Times A finds B spurs and gives it to him. B promises to give A 50 dash. This is a contract. Times A supports B's infant son. B promises to pay A's expenses in so doing. This is a contract. Times A owes B 1 000 but the debt is barred by the Limitation Act. A signs written promises to pay B 500 on account of the debt. This is a contract. Times A agrees to sell a horse worth of 1,000 for 10 dash. A's consent to the agreement was freely given. The agreement is a contract notwithstanding the inadequacy of the consideration. Times A agrees to sell a horse worth of 1,000 for 10 dash. A denies that his consent to the agreement was freely given. The inadequacy of the consideration is a fact which the court should take into account in considering whether or not A's consent was freely given. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 6. Agreement in restraint of marriage. Minor is void. Agreement in restraint of trade. Section 27 provides that every agreement by which anyone is restrained from exercising a lawful possession, trade or business of any kind is to that extent void. The exception to this section is saving of agreement not to carry on business of which goodwill is sold. One who sells the goodwill of a business may agree with the buyer to refrain from carrying on a similar business within specified local limits, so long as the buyer, or any person deriving title to the goodwill from him, carries on a like business therein, provide that such limits appear to the court reasonable, regard being had to the nature of business. Agreements in restraint of legal proceedings. Section 28 provides that every agreement A. by which any party thereto is restricted absolutely from enforcing his rights under or in respect of any contract, by the usual legal proceedings in the ordinary tribunals, or which limits the time within which he may thus enforce his rights, or B. which extinguishes the rights of any party thereto, or discharges any party thereto from any liability, under or in respect of any contract on the expiry of a specified period so as to restrict any party from enforcing his rights, is void to that extent. Exceptions. The following are the exceptions to this section. Time saving of contract. To refer to arbitration dispute that may arise, this section shall not render illegal a contract by which two or more persons agree that any dispute which may arise between them in respect of any subject or class of subjects shall be referred to arbitration, and that only the amounts awarded in such arbitration shall be recoverable in respect of the dispute so referred. Time saving of contract. To refer questions that have already arisen, nor shall this section render illegal any contract in writing by which two or more persons agree to refer to arbitration any question between them which has already arisen, or affect any provision of any law in force for the time being as to references to arbitration. Time saving of a guarantee agreement of a bank or a financial institution. This section shall not render illegal a contract in writing by which any bank or financial institution stipulate a term in a guarantee or any agreement making a provision for guarantee for extinguishment of the rights or discharge of any party thereto from any liability under or in respect of such guarantee or agreement on the expiry of a specified period, which is not less than 1 year from the date of occurring or non-occurring of a specified event for extinguishment or discharge of such party from the said liability. Agreements void for uncertainty. Section 29 provides that agreements, the meaning of which is not certain or capable of being made certain, are void. Examples. A agrees to sell to B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. The agreement is void for uncertainty. B. A agrees to sell to B 100 tons of oil of specified description known as an article of commerce. There is no uncertainty here to make to agreement void. C. A, who is a dealer in coconut oil only, agrees to sell to B 100 tons of oil. The nature of A's trade affords an indication of the meanings of the words, and has entered into a contract for the sale of 100 tons of coconut oil. The Institute of Cost Accountants of India. Laws and Ethics. 7. D. A agrees to sell to B all the grain in my granary at Ramnagar. There is no uncertainty here to make the agreement void. E. A agrees to sell to B 1,000 mounds of rice at a price to be fixed by C. As the price is capable of being made certain, there is no uncertainty here to make the agreement void. F. A agrees to sell to B my white horse for 500 or 1,000 dash. There is nothing to show which of the two prices was to be given. The agreement is void. Agreement by way of wager. Section 30 provides that agreements by way of wager are void, and no suit shall be brought for recovering anything alleged to be won on any wager, or entrusted to any person to abide the result of any game or other uncertain event on which any wager is made. Exception in favor of certain prizes for horse racing. This section shall not be deemed to render unlawful a subscription, or contribution, or agreement to subscribe or contribute, made or entered into for or toward any plate, prize, or sum of money of the value or amount of 500 or upwards to be awarded to the winner or winners of any horse race. Section 294 of the Indian Penal Code not affected. Nothing in this section shall be deemed to legalize any transaction connected with horse racing to which the provisions of Section 294 of the Indian Penal Code apply. 1.3 Consideration. Section 2(d) of the Act defines the term consideration as when, at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. Consideration is essential for every contract. The following are the fundamental principles for consideration. Times consideration must be at the desire of the promiser. Times consideration may move from the promise or any other person. In Chinnaya v. Ramaya, 1882, Mad. 137, it was held that a lady by a deed of gift made over certain property to her daughter directing her to pay an annuity to the donor's brothers, as had been done by the donor herself before she gifted the property. On the same day her daughter executed in writing in favor of the donor's brother agreeing to pay the annuity. Afterwards the Dun declined to fulfill her promise to pay her uncle, saying that no consideration had moved from him. The court held that the uncle could sue even though no part of the consideration received by the niece moved from him. The consideration from her mother was sufficient consideration. Types of consideration. Consideration may be of the following types. Times executory or future. It means it makes the form of promise to be performed in the future. Example, A makes an engagement with B to marry her in future. Times executed or present. It is an act or forbearance made or suffered for a promise. Times past. It means a past act or forbearance, that is to say, an act constituting consideration, took place and is complete before the promise is made. Legal rules regarding consideration. 1. It must move at the desire of the promiser. 2. It may move from the promisee or any other person. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 8. 3. Consideration must be something of value. 4. It may be an act, abstinence or forbearance or a written promise. 5. It may be past, present or future which the promiser is already not bound to do. 6. It must not be unlawful. 7. Consideration need not be adequate. 8. It must not be illusory. 9. It must not be opposed to public policy. 10. Pre-existing obligations. No consideration, no contract. Sect 25. The general rule is ex nudo pacto non oritur action, i.e., an agreement made without consideration is void. For example, if a promises to pay B 1,000 without any obligation from B, this is a void agreement for want of consideration. However, the Act itself provides exceptions to this rule in Section 25 itself. As per Section 25, an agreement made without consideration is not void in the following circumstances. 1. Promise made on account of natural love and affection. 2. Promise to compensate for voluntary services. 3. Promise made to pay a time-barred debt. Also, an agreement without consideration is not void in the following cases. 1. Gift actually made. 2. Creation of agency. 3. Charitable subscription. Stranger to contract. Doctrine of privity of contract. The doctrine of privity of contract means that a contract is between the parties only and no third person can sue upon it. It means that a stranger to contract cannot sue upon it. The Supreme Court of India recognized this rule in M.C. Chakko v. State Bank of Travancore. It is settled law that a person not a party to a contract cannot, subject to certain well-recognized exceptions, enforce the terms of the contract. Under the English common law, only a person who is party to a contract can sue upon it. In India, the common law doctrine of privity of contract is applicable. In the course of time, the courts have introduced a number of exceptions to rule of privity of contract. The Indian Contract Act, 1872 is silent about the right of a stranger to contract to sue or not to sue, but the Privity Council extended the principle of English common law to India in its decision in Jamna Das v. Ram Avatar Pandey, which was affirmed by the Honourable Supreme Court of India in the case of M.C. Chacko v. State Bank of Travancore. Accordingly, in the following circumstances, a stranger to contract can sue 1. Beneficiaries under trust or charge. 2. Marriage settlement, partition or other family arrangements. 3. Acknowledgement or estoppel. 4. Agency. 5. Assignee in case of insurance policy. The Institute of Cost Accountants of India. Laws and Ethics. 9. 1.4 Legality of object. The object of the contract is the ultimate purpose which the contract subserves. In contract, the subject matter or the agreement is its object. Section 23 discusses about the legality of the object or consideration. The said section provides that the consideration or object of an agreement is lawful unless times it is forbidden by law or times is of such nature that, if permitted, it would defeat the provisions of any law or times is fraudulent or times involves or implies injury to the person or property of another or times the court regards it as immoral or opposed to public policy. In each of these cases, the consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. Examples. A agrees to sell his house to B for 10,000 Here B is promised to pay the sum of 10,000 is the consideration for A's promise to sell the house, and A's promise to sell the house is the consideration for B's promise to pay 10,000 These are lawful considerations. B promises to pay B 1,000 at the end of 6 months if C, who owes that sum to B, fails to pay it. B promises to grant time to C accordingly. Here the promise of each party is the consideration for the promise of the other party, and they are lawful considerations. C promises for a certain sum paid to him by B to make good to B the value of his ship if it is wrecked on a certain voyage. Here, A's promise is the consideration for B's payment, and B's payment is the consideration for A's promise, and these are lawful considerations. D promises to maintain B's child, and B promises to pay A 1,000 yearly for the purpose. Here, the promise of each party is the consideration for the promise of the other party. They are lawful considerations. A, B and C enter into an agreement for the division among them of gains acquired, or to be acquired, by them by fraud. The agreement is void, as its object is unlawful. F promises to obtain for B an employment in the public service, and B promises to pay 1,000 to A. The agreement is void, as the consideration for its unlawful. G being agent for a landed proprietor, agrees for money, without the knowledge of his principal, to obtain for B a lease of land belonging to the principal. The agreement between A and B is void, as it implies a fraud by concealment by A on his principal. H promises B to drop a prosecution which he has instituted against B for robbery, and B promises to restore the value of the things taken. The agreement is void, as its object is unlawful. I. A's estate is sold for arrears of revenue under the provisions of an act of the legislature, by which the defaulter is prohibited from purchasing the estate. B, upon an understanding with A, becomes the purchaser, and agrees to convey the estate to A upon receiving from him the price which B has paid. The agreement is void, as it renders the transaction in effect, a purchase by the defaulter, and would so defeat the object of the law. J. A., who is B.S. Mukhtar, promises to exercise his influence, as such, with B in favor of C, and C promises to pay 1,000 to A. The agreement is void because it is immortal. K. A agrees to let her daughter to hire to B for concubinage. The agreement is void because it is immoral, though the letting may not be punishable under the Indian Penal Code. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 10. 1.5 E-contracts. Electronic contracts are paperless contracts and are in an electronic form. It is the change of technology and legal requirements lead the contract to be in electronic form. E-contract is a contract modeled, specified, executed, and deployed by a software system. They are conceptually very similar to traditional commercial contracts. E-contract also requires the basic elements of a contract. The following are ingredients of the e-contracts: times an offer is to be made, times offer is to be accepted, times there shall be a lawful consideration, times there shall be an intention to create legal relations, times the parties must be competent to contract, times there must be free and genuine consent, times the object of the contract must be lawful, times there must be certainty and possibility of performance. The main feature of this type of contract is speed, accurate, and reliable. The parties to the contract have to obtain digital signature from the competent authority, and they have to affix the digital signature instead of manual signing. The Information Technology Act, 2000 regulates such e-contracts. In this type of contract, the website of the offeror acts as a display to the world at large. Emails are used to negotiate and agree on contract terms and to send and agree to the final contract. An email contract is enforceable if the requirements of the contract are fulfilled. Electronically signed contracts cannot be denied because they are in electronic form and delivered electronically. 1.6 Constraints to enforce contractual obligations. Capacity of contract, who are competent to contract. Section 11. As per Section 11, every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind, and is not disqualified from contracting by any law to which he is subject. From the above provisions of the section, it means the following types of persons are not competent to contract. A. A person who has not attained the age of majority, i.e. minor. B. A person of unsound mind. C. A person who is disqualified from contracting by some law. A. Minor. As per Section 3 of the Indian Majority Act of 1875, every person in India is a minor if he has not attained the age of 18 years of age. However, in case of a minor of whose person or property or both a guardian has been appointed under the Guardian and Wards Act, 1890, or whose property is under the superintendence of any court of wards before he attains 18 years of age, is 21 years. The Institute of Cost Accountants of India. Laws and Ethics. 11. 11. The position of minors' agreement and effect thereof is as under. 1. An agreement with a minor is void ab initio. 2. The law of estoppel does not apply against a minor. It means a minor can always plead his minority despite earlier misrepresenting to be a major. In other words, he cannot be held liable on an agreement on the ground that since earlier he had asserted that he had attained majority. 3. Doctrine of restitution does not apply against a minor. In India, the rules of restitution by minor are similar to those found in English laws. The scope of restitution of contract by minor was examined by the Privy Council in Mohiri Bibi case when it has held that the restitution of money under Section 64 of the Indian Contract Act cannot be granted under Section 65 because a minor's agreement is not voidable but absolutely void ab initio. Similarly, no relief can be granted under Section 65 as this section is applicable where the agreement is discovered to be void or the contract becomes void. 4. No ratification on attaining majority. Ratification means approval or confirmation. A minor cannot confirm an agreement made by him during minority on attaining majority. If he wants to ratify the agreement, a fresh agreement and fresh consideration for the new agreement is required. 5. Contract beneficial to minor. A minor is entitled to enforce a contract which is of some benefit to him. Minority is a personal privilege, and a minor can take advantage of it and bind other parties. 6. Minor as an agent. A minor can be appointed an agent, but he is not personally liable for any of his acts. 7. A minor's liability for necessities. If somebody has supplied a minor or his dependents with necessities, minor's property is liable but a minor cannot be held personally liable. 8. A minor cannot be adjudged insolvent, as he is incapable of entering into a contract. 9. Where a minor and an adult jointly enter into an agreement with another person, the minor is not liable and the contract can be enforced against the major person. B. Sound mind person. What is a sound mind for the purposes of contracting? Section 12. A person is said to be of sound mind for the purposes of making a contract if, at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interests. A person who is usually of unsound mind, but occasionally of sound mind, may make a contract when he is of sound mind. A person who is usually of sound mind, but occasionally of unsound mind, may not make a contract when he is of unsound mind. Illustrations. A. A patient in a lunatic asylum, who is at intervals of sound mind, may contract during those intervals. B. A sane man, who is delirious from fever or who is so drunk that he cannot understand the terms of a contract or form a rational judgment as to its effect on his interests, cannot contract whilst such delirium or drunkenness lasts. Going by the spirit of the section, it is clear that a person is of sound mind if he fulfills the two conditions at the time when he makes it, namely, I. He/she is capable of understanding the contract. 2. He/she is capable of forming a rational judgment about the effects of such contract on his interest. A person not satisfying any of these two conditions is not treated as a person of sound mind. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 12. C. Other disqualified persons. The persons who are disqualified from entering into contract due to certain other reasons may be from legal status, political status or corporate status. Some of such categories of persons are given below. I. Alien enemy. An agreement with an alien enemy is void. But agreement with an alien friend is perfectly valid and enforceable. When the government of an alien is at war with the government of India, the alien is called alien enemy, who cannot enter into any contract with any Indian citizen without the permission of Government of India, as the same is public policy. Contract entered into with an alien before war is put into suspension during the duration of war. 2. Foreign sovereign and ambassadors. Foreign sovereigns and their representatives enjoy certain privileges and immunities in every country. They cannot enter into contract except through their agents residing in India. They can sue the Indian citizen, but an Indian citizen cannot sue them. 3. Convicts. A convict cannot enter into a contract while he is undergoing imprisonment. 4. Insolvents. An insolvent person is one who is unable to discharge his liabilities and therefore has applied for being adjudged insolvent, or such proceedings have been initiated by any of his creditors. An insolvent person cannot enter into any contract relating to his property. We, company or statutory bodies, a contract entered into by a corporate body or statutory body will be valid only to the extent it is within its memorandum of association. Free consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. Sec. 13. If the parties have not agreed upon the same thing in the same sense, there is no real consent and hence no contract is formed. As per Section 14 of the Indian Contract Act, 1872, consent is said to be free when it is not caused by 1. Coercion, Sec. 15, or 2. Undue influence, Sec. 16, or 3. Fraud, Sec. 17, or 4. Misrepresentation, Sec. 18, or 5. Mistake, subject to the provisions of Sec. 20, 21 and 22. The Institute of Cost Accountants of India. Laws and Ethics. 13. Coercion, Sec. 15. The term coercion has been defined in Section 15 of the Act as the committing or threatening to commit any act forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. Explanation. It is immaterial whether the Indian Penal Code is or is not in force in the place where the coercion is employed. From the above definition of coercion given in Section 15, consent is said to be caused by coercion when it is obtained by any one of the following: I. Committing or threatening to commit any act forbidden by Indian Penal Code. 2. Unlawful detaining or threatening to detain the property of another person. Coercion may come from a person party to the contract, or even third person not connected with the contract directly. Unlawful detaining also amounts to coercion if a person unlawfully detains or gives a threat to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement, amounts to coercion. Effect of coercion. According to Section 19, when the consent is caused by coercion, fraud, misrepresentation, the agreement is avoidable at the option of the party whose consent was so caused. The aggrieved party may opt to rescind the contract. If the aggrieved party seeks to rescind the contract, he must restore the benefits so obtained under the contract from other party. It should be noted that threat to commit suicide also amounts to coercion. Some special cases, which are prone to be construed cases of coercion, are discussed as under. 1. Prosecution. A mere threat to prosecute a man or file suit against him does not constitute coercion. In the case of Andhra Sugar Lts v State of APAIR 1968 SC 599, it was held that compulsion of law is not a coercion, fraud, misrepresentation, mistake, or even undue influence. To high prices and high interest rates, charging high interest rate, high price, etc., is not coercion, as the same is not prohibited under the Indian Penal Code. 3. A threat to commit suicide. Consent to an agreement may at times be obtained by threatening to commit suicide. The Madras High Court has held that threat to commit suicide amounts to coercion. In Amraju v Seshamma 1917-41 Mat 33, it was argued by Oldfield J., one of the judge of the bench which decided this case, that Section 15 of the Indian Contract Act must be construed strictly, and that an act which is not punishable under the Indian Penal Code cannot be said to be forbidden by it. Suicide is not punishable by the Indian Penal Code, only the attempt to suicide is punishable. Undue influence, Sec 16. Section 16 of the Indian Contract Act defines undue influence as under I. A contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. 2. In particular, and without prejudice to the generality of the foregoing principle, a person is deemed to be in a position to dominate the will of another. A. Where he holds a real or apparent authority over the other, or where he stands in a fiduciary relation to the other, or the Institute of Cost Accountants of India. Indian Contract Act, 1872. 14. B. Where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, or mental or bodily distress. 3. Where a person, who is in a position to dominate the will of another, enters into a contract with him, and the transaction appears, on the face of it or on the evidence adduced, to be unconscionable, the burden of proving that such contract was not induced by undue influence shall lie upon the person in a position to dominate the will of the other. Nothing in this subsection shall affect the provisions of Section 111 of the Indian Evidence Act, 1872, 1 of 1872. There is presumption of undue influence in the following relationships: I. Parent and child; 2. Guardian and ward; 3. Doctor and patient; 4. Solicitor and client; v. Trustee and beneficiary; 6. Religious advisor and disciple; 7. Fiancé and fiancée. There is, however, no presumption of undue influence in case of relationship of I. Landlord and tenant; 2. Debtor and creditor; 3. Husband and wife. The wife has to be Pardhanshi for such presumption. In these relationships, undue influence has to be proved. Going through the definition of undue influence in Section 16, we find that two elements are found in undue influence. I. The relationship subsisting between the parties is such that one party is in a position to dominate the will of other, and 2. He uses that position to obtain an unfair advantage over the other. The person intending to avoid the contract on the ground of undue influence must prove both the above two elements. Examples: A. Having advanced money to his son; B. During his minority, upon B's coming of age obtains, by misuse of parental influence, a bond from B for a greater amount than the sum due in respect of the advance. A. Employs undue influence. B. A man enfeebled by disease or age is induced, by B's influence over him as his medical attendant, to agree to pay B an unreasonable sum for his professional services. B. Employs undue influence. C. A. Being in debt to B, the moneylender of his village, contracts a fresh loan on terms which appear to be unconscionable. It lies on B to prove that the contract was not induced by undue influence. D. A. Applies to a banker for a loan at a time when there is stringency in the money market. The banker declines to make the loan except at an unusually high rate of interest. A. Accepts the loan on these terms. This is a transaction in the ordinary course of business, and the contract is not induced by undue influence. The Institute of Cost Accountants of India. Laws and Ethics. 15. Effect of undue influence. Section 19 provides that when the consent is caused by undue influence, the agreement is voidable at the option of the party whose consent was so caused. The aggrieved party may opt to rescind the contract. If the aggrieved party seeks to rescind the contract, he must restore the benefits so obtained under the contract from other party, upon such terms and conditions as to the court may seem just. The following illustrations are appended to the section. A. A's son has forged B's name to a promissory note. B. Under threat of prosecuting A's son, obtains a bond from A for the amount of the forged note. If B sues on this bond, the court may set the bond aside. B. A moneylender, advances 100 to B, an agriculturist, and, by undue influence, induces B to execute a bond for 200 with interest at 6% per month. The court may set the bond aside, ordering B to repay 100 with such interest as may seem just. The court has discretion to direct the aggrieved party for giving back the benefit whether in whole or in part or set aside the contract without any direction for refund of benefit. In a case for avoiding a contract on the ground of undue influence, the plaintiff has to prove that I, the other party, was in a position to dominate the will, and 2. He actually used his influence to obtain the plaintiff's consent to the contract. It will be then for the defendant to show that the plaintiff freely consented. The presumption is raised at least in the following cases: A. Unconscionable bargains. B. Contracts with Pardanshi women. Fraud, Sec 17. As per Section 17 of the Indian Contract Act, fraud means and includes any of the following acts committed by a party to a contract, or with his connivance, or by his agent, with intent to deceive another party thereto or his agent, or to induce him to enter into the contract, I. The suggestion, as a fact, of that which is not true by one who does not believe it to be true, 2. The active concealment of a fact by one having knowledge or belief of the fact, 3a. Promise made without any intention of performing it, 4. Any other act fitted to deceive, v. Any such act or omission as the law specially declares to be fraudulent. Explanation: mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that, regard being had to them, it is the duty of the person keeping silence to speak, or unless his silence is, in itself, equivalent to speech. Does silence amount to fraud? At times one of the parties to a contract makes silence to some of the facts relating to the subject matter of contract. The matter on which silence is maintained by party may be material fact. Does this amount to passive fraud under the Indian Contract Act or not depends upon various factors? Explanation to Section 17 of the Indian Contract Act provides that mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud unless the circumstances of case are such that, having regard to them, it is the duty of the person keeping silence to speak, or unless silence itself is equivalent to speech. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 16. Thus, we can say that there is exception to the rule that mere silence does not amount to silence. These two exceptions are provided in explanation to Section 17, and these are as under. I. When there is a duty to speak. 2. Where silence is equivalent to speech. However, in the following two types of cases, silence amounts to fraud, as held by the courts in various cases. A. Where there is change in circumstances, a representation may be true when made, but with the passage of time, or changed circumstances, it may become false. Accordingly, this must be communicated to other party, otherwise it amount to fraud. B. When there is half-truth, even when a person is not bound to disclose a fact, he may be held guilty of fraud if he volunteers to disclose a state of fact partly. This is so when the undisclosed part renders the disclosed part false. Examples: A. Sells, by auction, to B, a horse which A knows to be unsound. A says nothing to B about the horse's unsoundness. This is not fraud in A. B. B is A's daughter and has just come of age. Here, the relation between the parties would make it A's duty to tell B if the horse is unsound. C. B says to A, "If you do not deny it, I shall assume that the horse is sound." A says nothing. Here, A's silence is equivalent to speech. D. A and B, being traders, enter upon a contract. A has private information of a change in prices which would affect B's willingness to proceed with the contract. A is not bound to inform B. Effect of fraud. According to Section 19, when consent to an agreement is caused by coercion, fraud, or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. A party to a contract whose consent was caused by fraud or misrepresentation may, if he thinks fit, insist that the contract shall be performed and that he shall be put in the position in which he would have been if the representations made had been true. However, there is one exception to the rule of voidability of contract at the option of aggrieved party. If such consent was caused by misrepresentation or by silence, fraudulent within the meaning of Section 17, the contract, nevertheless, is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. Misrepresentation, Sec. 18. A statement of fact which one party makes in the course of negotiation with a view to induce the other party to enter into a contract is known as misrepresentation. It must relate to some fact which is material to the contract. It may be expressed by words spoken or written or implied from the acts and conduct of the parties. A representation, when wrongly made either innocently or unintentionally, is a misrepresentation. When it is made innocently or unintentionally, it is misrepresentation, and when made intentionally or willfully, it is fraud. Misrepresentation has been defined in Section 18 of the Act as under. Misrepresentation means and includes 1. The positive assertion, in a manner not warranted by the information of the person making it, of that which is not true, though he believes it to be true. The Institute of Cost Accountants of India. Laws and Ethics. 17. 2. Any breach of duty which, without an intent to deceive, gains an advantage to the person committing it, or any one claiming under him, by misleading another to his prejudice or to the prejudice of anyone claiming under him. 3. Causing, however innocently, a party to an agreement to make a mistake as to the substance of the thing which is the subject of the agreement. From the above definition of the term misrepresentation, the following two types of misrepresentations are noticed. A. Unwarranted statements, when a person positively asserts, makes an absolute and explicit statement of facts. That fact is true, though he has no reliable source to form this opinion, but he believes it to be true. This is one type of misrepresentation. B. Breach of duty. Any breach of duty which brings advantages to the person committing it by misleading the other to his prejudice is a misrepresentation. Effect of misrepresentation. As per Section 19, when consent to an agreement is caused by misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. A party to a contract whose consent was caused by misrepresentation may, if he thinks fit, insist that the contract shall be performed and that he shall be put in the position in which he would have been if the representations made had been true. Exception, if such consent was caused by misrepresentation or by silence, fraudulent within the meaning of Section 17, the contract, nevertheless, is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. Explanation. A fraud or misrepresentation which did not cause the consent to a contract of the party on whom such fraud was practiced, or to whom such misrepresentation was made, does not render a contract voidable. Examples: A. Intending to deceive B, falsely represents that 500 mounds of indigo are made annually at A's factory, and thereby induces B to buy the factory. The contract is voidable at the option of B. A. By a misrepresentation, leads B erroneously to believe that 500 mounds of indigo are made annually at A's factory. B examines the accounts of the factory, which show that only 400 mounds of indigo have been made. After this, B buys the factory. The contract is not voidable on account of A's misrepresentation. C. A fraudulently informs B that A's estate is free from encumbrance. B thereupon buys the estate. The estate is subject to a mortgage. B may either avoid the contract or may insist on its being carried out and the mortgage debt redeemed. B, having discovered a vein of ore on the estate of A, adopts means to conceal, and thus conceal, the existence of the ore from A. Through A's ignorance, B is enabled to buy the estate at an undervalue. The contract is voidable at the option of A. A is entitled to succeed to an estate at the death of B. B dies. C, having received intelligence of B's death, prevents the intelligence reaching A, and thus induces A to sell him his interest in the estate. The sale is voidable at the option of A. Mistake, Sec 20, 21 and 22. Mistake means an erroneous belief about something. It has not been defined in the Indian Contract Act. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 18. Mistake can be A. Mistake of law, or Sec 21, B. Mistake of fact, Sec 20. A. Mistake of law may be I. Mistake of law of the country. 2. Mistake of law of a foreign country. I. Mistake of law of the country. When a party enters into a contract without the knowledge of law in the country, the contract is affected by such mistake, but it is not void. A contract is not voidable because it was caused by a mistake as to any law in force in India. The reason here is that ignorance of law is not an excuse at all. However, if a party is induced to enter into a contract by the mistake of law, then such a contract may be avoided. 2. Mistake of law of foreign country. Such a mistake is treated as mistake of fact, and agreement is such case is void. B. Mistake of fact may be I. Bilateral mistake, or 2. Unilateral mistake. I. Bilateral mistake where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. Explanation: an erroneous opinion as to the value of the thing which forms the subject matter of the agreement is not to be deemed a mistake as to a matter of fact. In order to render an agreement void due to bilateral mistake, the following two conditions must be met. A. Mistake must be mutual. Both the parties must misunderstand each other and should be at cross purpose. B. Mistake must relate to a matter of fact essential to the agreement. What is essential fact of an agreement depends upon the nature of promise in each case. The various types of mistakes falling under bilateral mistakes are as under. I. Mistake as to subject matter covers following cases. A. Mistake as to existence of subject matter. If both the parties are at mutual mistake as to existence of the subject matter, the agreement is void. B. Mistake as to identity of subject matter. It usually happens when both the parties have different subject matter of contract in their mind. The agreement is void due to mistake of identify of subject matter. C. Mistake as to the quality of the subject matter. If the subject matter is something essentially different from what the parties thought to be, the agreement is void. D. Mistake as to quantity of subject matter. Bilateral mistake as to quantity of subject matter would render the agreement void. E. Mistake as to title of subject matter. The agreement is void due to bilateral mistake as to title of the subject matter. The Institute of Cost Accountants of India. Laws and Ethics. 19. F. Mistake as to price of the subject matter. Mutual mistake as to price of the subject matter would render the agreement void. 2. Mistake as to possibility of performance of contract. Impossibility may be A. Physical impossibility. An agreement is void if it is identified to be non-feasible due to physical factors like time, distance, height, etc. B. Legal impossibility. An agreement is void if it provides that something shall be done which as a matter of law cannot be done. Examples. A. A agrees to sell to B a specific cargo of goods supposed to be on its way from England to Bombay. It turns out that, before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. Neither party was aware of these facts. The agreement is void. B. A agrees to buy from B a certain horse. It turns out that the horse was dead at the time of bargain, though neither party was aware of the fact. The agreement is void. C. A, being entitled to an estate for the life of B, agrees to sell it to C. B was dead at the time of the agreement, but both parties were ignorant of the fact. The agreement is void. 2. Unilateral mistake as to fact. As per Section 22, a contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to a matter of fact. A unilateral mistake is not allowed as a defense in avoiding a contract unless brought about by another party's fraud or misrepresentation. 1.7 Quasi-contracts, contingent contracts, termination or discharge of contracts. Quasi-contracts. Sometimes the law implies a promise imposing obligations on one party and conferring the right in favor of the other even when there is no offer, no acceptance, no consensus ad idem, and in fact, there is neither agreement nor promise. Such cases are not contracts, but the court recognizes them as relations resembling those of contracts and enforces them as if they were contracts. Such is called as a quasi-contract. This type of contract rests on the equitable principle that a person shall not be allowed to enrich himself unjustly in the experience of another. It is obligation which the law creates in the absence of any agreement when any person is in the possession of one person's money or its equivalent under such circumstances that in equity and good conscience he ought not to retain it, and which in justice and fairness belongs to another. It is the duty and not an agreement or intention which defines it. In the Act, the following type of quasi-contracts are discussed. Times Section 68. Claim for necessaries supplied to person incapable of contracting, or on his account. This section provides that if a person, incapable of entering into a contract, or any one whom he is legally bound to support, is supplied with another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. Examples. A supplies B, a lunatic, with necessaries suitable to his condition in life. A is entitled to be reimbursed from B's property. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 20. B. A supplies the wife and children of B, a lunatic, with necessaries suitable to their condition in life. A is entitled to be reimbursed from B's property. Times Section 69. Reimbursement of persons paying money due by another, in payment of which he is interested. This section provides that a person who is interested in the payment of money which another is bound by law to pay, and who therefore pays it, is entitled to be reimbursed by the other. Examples: B holds land in Bengal on a lease granted by A, the Zmindar. The revenue payable by A to the government being in arrear, his land is advertised for sale by the government. Under the revenue law, the consequence of such sale will be the annulment of lease. B. To prevent the sale and the consequent annulment of his own lease, pays to the government the sum due from A. A is bound to make good to B the amount so paid. Times Section 70. Obligation of person enjoying benefit of Non-Gratuitous Act. This section provides that where a person lawfully does anything for another person, or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of, or to restore, the thing so done or delivered. It is otherwise called as quantum meruit. Examples: A tradesman, leaves goods at B's house by mistake. B treats the goods as his own. He is bound to pay A for them. B. A saves B's property from fire. A is not entitled to compensation from B if the circumstances show that he intended to act gratuitously. Times Section 71. Responsibility of finder of goods. This section provides that a person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as a bailee. Times Section 72. Liability of person to whom money is paid or thing delivered by mistake or under coercion. This section provides that a person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. Examples: A and B jointly owe 100 rupees to C. A alone pays the amount to C, and B, not knowing this fact, pays 100 rupees over again to C. C is bound to repay the amount to B. B. A railway company refuses to deliver up certain goods to the consignee, except upon the payment of an illegal charge for carriage. The consignee pays the sum charged in order to obtain the goods. He is entitled to recover so much of the charge as was illegally excessive. Contingent contracts. Section 31 defines contingent contract as a contract to do or not to do something if some event, collateral to such contract, does or does not happen. The following are the essentials of contingent contract. Example: A contracts to pay B 10,000 if B's house is burnt. This is a contingent contract. The following are the essentials of a contingent contract. Time's uncertainty and futurity of the event to which it is related. Time's uncertain future event must be collateral to the contract. The Institute of Cost Accountants of India. Laws and Ethics. 21. An agreement to sell unspecified half share in the property is not contingent contract as held in Harbakhash Singh Gill v. Ram Ratan AIR 1988 P&H 60. In Bhairav Prasad Chaursia v. SMT. Tara Devi AIR 1980 all. 36 It was held that an agreement to sell a house is by no means a contingent contract. An agreement to purchase a property is neither a contingent contract nor can it be characterized as a mere possible right or interest. It was contended that the contract is a contingent contract because of either of the parties to the contract may refuse to perform his part on the contract. The court held that the argument is fallacious. Such a contingency would not be a collateral to a contract. An agreement to purchase a property is neither a contingent contract nor can it be characterized as a mere possible right of interest. Reciprocal promises are not contingent contracts, as they cannot be said to be collateral to each other. The law allows the enforcement of a contingent contract after the event upon which it was contingent has happened. The contingency, which is the essence of a condition, must be distinguished from mere futurity. An obligation is not to be classified as conditional because its performance is not yet due. A contingent contract need not necessarily be independent on any external event. It may be conditional on the voluntary act or the future conduct of one of the parties or a third person. Enforcement of contingent contract. Section 32 provides that contingent contracts to do or not to do anything, if an uncertain future event happens, cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contracts become void. Examples: A makes a contract with B to buy B's horse if A survives C. This contract cannot be enforced in law unless and until C dies in A's lifetime. B makes a contract with B to sell a horse to B at a specified price if C, to whom the horse has been offered, refuses to buy him. The contract cannot be enforced by law unless and until C refuses to buy the horse. C. A contract to pay B a sum of money when B marries C, C dies without being married to B. The contract becomes void. Section 33 provides for enforcement of contracts contingent on an event not happening. This section provides that contingent contracts to do or not to do anything if an uncertain future event does not happen, can be enforced when the happening of that event becomes impossible, and not before. Explanation: A agrees to pay B a sum of money if a certain ship does not return. The ship is sunk. The contract can be enforced when the ship sinks. Section 34 discusses about deemed impossible contract. The said section provides that if the future event on which a contract is contingent is the way in which a person will act at an unspecified time, the event shall be considered to become impossible when such person does anything which renders it impossible that he should so act within any definite time, or otherwise than under further contingencies. Example: A agrees to pay B a sum of money if B marries C, C marries D. The marriage of B to C must now be considered impossible, although it is possible that D may die, and that C may afterwards marry B. Section 35 provides for the contracts, which are contingent on happening of specified event within fixed time. The said section provides that contingent contracts to do or not to do anything, if a specified. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 22. Uncertain event happens within a fixed time, become void if, at the expiration of the time fixed, such event has not happened, or if, before the time fixed, such event becomes impossible. Contingent contracts to or not to do anything, if a specified uncertain event does not happen within a fixed time, may be enforced by law when the time fixed has expired and such event has not happened, or before the time fixed has expired, if it becomes certain that such event will not happen. Examples: A promises to pay B a sum of money if a certain ship returns within a year. The contract may be enforced if the ship returns within the year, and becomes void if the ship is burnt within the year. B promises to pay B a sum of money if a certain ship does not return within a year. The contract may be enforced if the ship does not return within the year, or is burnt within the year. Agreements contingent on impossible event void. Section 36 provides that contingent agreements to do or not to do anything, if an impossible event happens, are void, whether the impossibility of an event is known or not to the parties to the agreement at the time when it is made. Example: A. A agrees to pay B 1,000 if two straight lines should enclose a space. This agreement is void. B. A agrees to pay B 1,000 if B will marry A's daughter C. C was dead at the time of the agreement. The agreement is void. Discharge of contracts: when the rights and obligations created by a contract come to an end, the contract is said to be discharged or terminated. In other words, discharge of contract means termination of contractual relationship between the parties. Modes of discharge of contracts: the following are the various modes or methods by which a contract is discharged. Discharge amounts to end of a contract. 1. Discharge by performance. 2. Discharge by agreement. 3. Discharge by lapse of time. 4. Discharge by operation of law. 5. Discharge by impossibility of performance. 6. Discharge by breach of contract. 1. Discharge by performance. Performance is the usual mode of discharge of a contract. Performance may be A. Actual performance, B. Attempted performance. Actual performance is the fulfillment of the obligations arising from a contract by the parties to it, in accordance with the terms of the contract. The Institute of Cost Accountants of India. Laws and Ethics. 23. Offer of performance is also known as attempted performance or tender of performance. A valid tender of performance is equivalent to performance. Modes of discharge: discharge by performance, discharge by agreement, discharge by lapse of time, discharge by operation of law. Discharge by impossibility of performance. Discharge by breach of contract. 1. Novation. 2. Alteration. 3. Recession. 4. Remission. 5. Waiver. 1. Debt. 2. Insolvency. 3. Unauthorized material alternation. 4. Merger. Actual performance, attempted performance. 2. Discharge by agreement. The parties may agree to terminate the existence of the contract by any of the following ways: A. Novation. B. Alteration. C. Rescission. D. Remission. E. Waiver. A. Novation, substitution of a new contract in place of the existing contract, is known as novation of contract. It discharges the original contract. The new contract may be between the same parties or between different parties. Novation can take place only with the consent of all the parties. Example: A owes money to B under a contract. It is agreed between A, B and C that B should accept C as his debtor instead of A. The old debt of A and B is at an end, and a new debt from C to B has been contracted. There is novation involving change of parties. B. Alteration. Alteration means change in one or more of the terms of the contract. In case of novation, there may be a change of the parties, while in the case of alteration, the parties remain the same. But there is a change in the terms of the contract. C. Rescission. Rescission means cancellation. All or some of the terms of a contract may be cancelled. Rescission results in the discharge of the contract. Example: A promises to deliver certain goods to B at a certain date. Before the date of performance, A and B mutually agree that the contract need not be performed. The contract stands discharged by rescission. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 24. D. Remission. Remission means acceptance of a lesser performance, that what is actually due under the contract. There is no need of any consideration for remission. Example, A has borrowed 500 rupees from B. A agrees to accept 250 rupees from B in satisfaction of the whole debt. The whole debt is discharged. Waiver. Waiver means giving up or foregoing certain rights. When a party agrees to give up its rights, the contract is discharged. Example, A promises to paint a picture of B. B afterwards forbids him to do so. A is no longer bound to perform the promise. 3. Discharge by lapse of time. Every contract must be performed within a fixed or reasonable period. Lapse of time discharges the contract. The Indian Limitation Act has prescribed the period within which the existing rights can be enforced in courts of law. Example, if a creditor does not file a suit within 3 years of debt, the debt becomes time-barred. He is deprived of his legal remedy. 4. Discharge by operation of law. A contract may be discharged by operation of law in the following cases. A. Death. B. Insolvency. C. Unauthorized material alteration. D. Merger. A. Death. In contracts involving personal skill or ability, death terminates the contracts. In other cases, the rights and liabilities of the deceased person will pass on to his legal representatives. B. Insolvency. The insolvency of the promisor discharges the contract. The promisor is discharged from all liabilities incurred prior to his adjudication. C. Unauthorized material alteration. Material alteration in the terms of the contract without the consent of the other party discharges the contract. Change in the amount of money to be paid, date of payment, place of payment, etc. are examples of material alteration. D. Merger. When inferior rights of a person under a contract merge with superior rights under a new contract, the contract with inferior rights will come to an end. Example, where a part-time lecturer is made full-time lecturer, merger discharges the contract of part-time lecturership. 5. Discharge by impossibility of performance. Impossibility of performance results in the discharge of the contract. An agreement which is impossible is void, because law does not compel to do impossible things. The Institute of Cost Accountants of India. Laws and Ethics. 25. 6. Discharge by breach. Breach means failure of a party to perform his obligations under a contract. Breach brings an end to the obligations created by a contract. Example, A and B wanted to marry each other. Before the time fixed for marriage, A goes mad. The contract becomes void. Termination of contract. The proper way in which the agreement could have been terminated by issuing of a notice to the plaintiff, calling upon to complete the transaction within a particular time, failing which the contract will be treated as cancelled. That this is the proper way of terminating the contract is clear from what has been observed in Narayana Swami Pilevi. Dhankodi Ammal, 1971, 1 MYS. LJ, 245, that when the contract is for the sale of immovable property, the vendor must give reasonable notice requiring the performance within a definite time. 1.8 Special Contracts, Indemnity and Guarantee, Bailment and Pledge, Laws of Agency. Contract of Indemnity and Guarantee. Chapter 8 of the Act deals with the contract of indemnity and guarantee. Sections 124 and 125 deal with the contract of indemnity. The other provisions deal with the contract of guarantee. Contract of indemnity. Section 124 of the Act defines the expression contract of indemnity as a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself, or by the conduct of any other person. Example, a contracts to indemnify B against the consequences of the proceedings which C may take against B in respect of a certain sum of 2 lakhs. This is a contract of indemnity. This contract includes indemnifier and indemnity holder. A person who promises to indemnify from losses is called as indemnifier, and the person whose loss is made good is called as indemnity holder. To indemnify does not merely means to reimburse in respect of monies paid, but to save from loss in respect of the liability for which the indemnity has been given. A contract of indemnity may be either expressed or implied. In Kapan Chettiar v. Ramaswamy Chettiar, ILR, 1947, Mad. 58, it was held that there is implied by law a contract by the person making the request to keep indemnified the person having the duty against any liability which may result from such exercise of the supposed duty. In the New India Assurance Co. Limited v. State Trading Corporation of India, AIR 2007, NOC 517, Guj, it was held that almost all insurance other than life and personal accident insurances are contracts of indemnity. In National Overseas v. Export Credit Guarantee Corporation of India Limited, AIR 2008 Call 18, it was held that where export risk policy issued by Export Credit Guarantee Corporation, an exporter had consigned shipments to buyer at his own risk without resorting to terms of policy, the corporation is not liable to indemnify loss caused to exporter. Rights of indemnity holder when sued. Section 125 provides the rights of indemnity holder when sued. This section provides that the promise, in a contract of indemnity, acting within the scope of his authority, is entitled to recover from the promisor times all damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 26. Times all costs which he may be compelled to pay in any such suit if, in bringing or defending it, he did not contravene the orders of the promisor, and acted as it would have been prudent for him to act in the absence of any contract of indemnity, or if the promisor authorized him to bring or defend the suit. Times all the sums which he may have paid under the terms of any compromise of any such suit, if the compromise was not contrary to the orders of the promisor, and was one which it would have been prudent for the promise to make in the absence of any contract of indemnity, or if the promisor authorized him to compromise the suit. This section is not exhaustive and does not set out all the reliefs which an indemnity holder who has been sued may get. It leaves untouched certain equitable reliefs which he may get. The rights of the indemnity holder are not confined to those mentioned in this section. Even before damage is incurred, it is open to him to sue for the specific performance of the contract of indemnity, provided that it is shown that an absolute liability has been incurred by him and that the contract of indemnity covers the said liability. In Pepin v. Chandra Sekur, ILR 5 calories. 811, it was held that in the case of contract of indemnity, the liability of the party indemnified to a third person is not only contemplated at the time of indemnity, but is the very moving cause of that contract, and in case of such a nature, the costs reasonably incurred in resisting or reducing or ascertaining the claim may be recovered. Contract of guarantee. Section 126 defines the expression the contract of guarantee as a contract to perform the promise or discharge the liability of a third person in case of his default. The components of this contract consist of times surety. The person who gives the guarantee is called as the surety. Times principal debtor. The person in respect of whose default the guarantee is given is called the principal debtor. times creditor, the person to whom the guarantee is given, is called the creditor. A guarantee may be either oral or written. It is a tripartite agreement which contemplates the principal debtor, the creditor, and the surety. Consideration for guarantee. Section 127 provides that anything done or any promise made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving guarantee. Examples: A. B requests A to sell and deliver to him goods on credit. A agrees to do so, provided C will guarantee the payment of the price of the goods. C promises to guarantee the payment in consideration of A's promise to deliver the goods. This is sufficient consideration for C's promise. B. A sells and delivers goods to B. C afterwards requests A to forbear to sue B for the debt for a year, and promises that, if he does so, C will pay for them in default of payment by B. A agrees to forbear as requested. This is a sufficient consideration for C's promise. C. A sells and delivers goods to B. C afterwards, without consideration, agrees to pay for them in default of B. The agreement is void. This section takes into its fold past consideration also. Like any other contract, a contract of guarantee must be supported by consideration. It is not necessary that the consideration should be received by the surety. Consideration between the principal debtor and the creditor is good consideration for the guarantee given by the surety. The Institute of Cost Accountants of India. Laws and Ethics. 27. In Rajendra v. Mahila Chandrabai, 2012, 1, MPLJ 164, the case is within the purview of example C. Merely because the appellant made promise to the plaintiff that in this case first and second defendants who were required to pay the sale price to her failed to pay the same, he would pay the sale price. That promise was without consideration, and therefore the said agreement between the plaintiff and third defendant was void. Needless to say that a void agreement cannot be enforced by law, and therefore, since the status of the appellant, third defendant, is that of a guarantor, his case is covered under the ambit of example copyright symbol to Section 127 of the Act, and he is not liable to pay the sale consideration or any other amount to the plaintiff on account of the failure in making the payment by first and second defendants. In United Breweries Holding Limited v. KSII and DC Limited, AIR 2012, NOC 154, call, it was held that it is clear that the question as to whether the deed in question is a deed of guarantee or not depends upon the terms under which the guarantor binds himself. Under law, he cannot be made liable for more than what he has undertaken. There is no ambiguity that the appellant has not undertaken that he would repay the loans of respondent number 2 in case if respondent number 2 fails to discharge its liability. Therefore, the appellant cannot be made liable for more than what it has undertaken. Distinction between indemnity and guarantee. The contract of indemnity differs from the contract of guarantee in the aspects shown in the following table. SL.No Contract of Indemnity, Contract of Guarantee. 1. In this contract there are two parties, the indemnifies and the indemnified. In this contract 3 parties are involved, principal debtors, surety and creditor. To the primary liability is on the indemnifier, the principal liability is on the principal debtors. Secondary liability is on the surety. 3. The indemnifier is not acting at the request of the debtor. The surety gives contract at the request of the principal debtor. 4. The possibility of any loss happening is the only contingency against which the indemnifier undertakes to indemnify. There is an existing debt for which the surety gives guarantee to the creditor on behalf of the principal debtor. 5. The indemnifier cannot sue the third party in his own unless there is an assignment. The surety is entitled to proceed against the principal debtor when he is obliged to perform the guarantee. 6. The contract is between the indemnifier and indemnified. The contract is between the principal debtor creditor, surety, creditor, principal debtor surety. Liability of surety. The liability of surety arises only when the principal debtor fails to pay the debt to the creditor. Section 128 provides for the liability of surety. The said section provides that the liability of the surety is coextensive with that of the principal debtor, unless it is otherwise provided by the contract. Example: a guarantee is to be the payment of a bill of exchange by C, the acceptor. The bill is dishonored by C. A is liable not only for the amount of the bill, but also for any charges which may have become due on it. The liability of the surety is coextensive with that of the principal debtor, and the surety is liable to pay the entire amount, his liability being immediate, as held in Gauri Prasad v. Rabo India Finance Limited, 2013, 2. MH.LJ 195. In Swaminatha Pillai v. Lakshman Iyer, AIR 1935 Mat 748, it was held that there is no authority for the general proposition that a creditor cannot proceed against the surety unless he has first exhausted all his remedies against the principal debtor. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 28. Where the letter of guarantee issued by a guarantor guarantees repayment of only the principal sum and does not guarantee the payment of any interest, he could not be made liable for the payment of interest as held in S.N. Prasad v. Monith Finance Limited, 2011, SCC 320. Continuing guarantee. Section 129 of the Act defines the expression continuing guarantee as a guarantee which extends to a series transactions. Examples: Times A, in consideration that B will employ C in collecting the rents of B.S. Mindari, promises B to be responsible to the amount of 5,000 for the due collection and payment by C of those rents. This is a continuing guarantee. Times A guarantees payment to B, a tea dealer, to the amount of $100 for any tea he may from time to time supply to C. B supplies C with tea to above the value of $100 and C pays B for it. Afterwards, B supplies C with tea to the value of $200. C fails to pay. The guarantee given by A was a continuing guarantee, and he is accordingly liable to B to the extent of $100. Times A guarantees payment to B of the price of 5 sacks of flour to be delivered to B to C and to be paid for in a month. B delivers 5 sacks to C, C pays for them. Afterwards, B delivers 4 sacks to C, which C does not pay for. The guarantee given by A was not a continuing guarantee, and accordingly he is not liable for the price of 4 sacks. A guarantee for a future performance may either be restricted to a debtor or liability of a certain amount to be incurred once for all, or it may be continuing. If the liability extends to a single transaction, it is specific. In case it extends to a series of transactions, it is continuing. In Gopinathan v. Nedungri Bank Limited, 2013, 3, KLT 115, it was held that on the strength of continuing guarantee, liability of the guarantors continued notwithstanding that the personal remedy against the second respondent stood discharged. Revocation of continuing guarantee. A continuing guarantee can be revoked by 2 ways. Times revocation by surety. Times revocation on the death of surety. Revocation of continuing guarantee by surety. Section 130 provides that a continuing guarantee may at any time revoked by the surety, as to future transactions by notice to the creditor. Example. Times A, in consideration of B's discounting at A's request, bills of exchange for C, guarantees to B, for 12 months, the due payment of all such bills to the extent of 5,000. B discounts bill for C to the extent of 2,000 dash. Afterwards, at the end of 3 months, A revokes guarantee. The revocation discharges A from all liability to B for any subsequent discount. But A is liable to B for 2,000 on default of C. Times A guarantees to B, to the extent of 10,000 that C shall pay all the bills that B shall draw upon C. C accepts the bill. A gives notice of revocation. C dishonors the bill at maturity. A is liable upon his guarantee. Revocation of continuing guarantee by surety's death. Section 131 provides that the death of the surety operates, in the absence of any contract to the contrary, as a revocation of continuing guarantee, so far as regards future transactions. The Institute of Cost Accountants of India. Laws and Ethics. 29. Discharge of surety. The liability of the surety is discharged under the following circumstances: times by giving notice to the creditor, Section 130, times by the death of the surety, Section 131, times by variance in terms of contract, Section 133, times by release or discharge of principal debtor, Section 134, times when creditor compounds with the principal debtor by giving time to or agrees not to sue principal debtor, Section 135, times by creditor act or omission impairing surety's eventual remedy, Section 139, which will not discharge the surety. In the following circumstances, the liability of the surety is not considered to be discharged: times Section 136, where a contract to give time to the principal debtor is made by the creditor with a third person, and not with the principal debtor, the surety is not discharged. Times Section 137, mere forbearance on the part of the creditor to sue the principal debtor or to enforce the other remedy against him, does not, in the absence of any provision in the guarantee to the contrary, discharge the surety. Example, B owes to C a debt guaranteed by A. The debt becomes payable. C does not sue B for a year after the debt has become payable. A is not discharged from his suretyship. Rights of surety. The following are the rights available to the surety under this Act: times Section 140, right of surety on payment or performance, where a guaranteed debt has become due, or default of the principal debtor to perform a guaranteed duty has taken place, the surety, upon payment or performance of all that he is liable for, is invested with all the rights which the creditor had against the principal debtor. Times Section 141. Surety's right to benefit of creditors' securities. A surety is entitled to the benefit of every security which the creditor had against the principal debtor at the time when the contract of suretyship is entered into, whether the surety knows of the existence of such security or not. And, if the creditor loses or, without the consent of the surety, parts with such security, the surety is discharged to the extent of the value of the security. Examples: times C advances to B, his tenant, 20,000 on the guarantee of A. C has also a further security for 20,000 by a mortgage of B's vehicle. C cancels the mortgage. B becomes insolvent, and C sues A on his guarantee. A is discharged from liability to the amount of the value of the furniture, times C. A creditor whose advance to B is secured by a decree receives also a guarantee for that advance from A. C afterwards takes B's goods in execution under the decree, and then, without the knowledge of A, withdraws the execution. A is discharged, times A, as surety for B, makes a bond jointly with B to C, to secure a loan from C to B. Afterwards, C obtains from B a further security for the same debt. Subsequently, C gives up further security. A is not discharged. Section 140 provides for subrogation, where the guarantor clears his liability by payment. He is invested with all rights which the creditor had with the principal debtor. The section enacts that in order that the Institute of Cost Accountants of India, Indian Contract Act, 1872, 30. The surety may be invested with all the rights which the creditor had against the principal debtor, the following conditions be fulfilled, namely, times the guaranteed debt must have become due, or the principal debtor must have made default in performing the guaranteed duty, and times the surety must have paid the debt, that is, the whole debt, or the surety must have performed all that is liable for. Unless the said two conditions have been fulfilled, the surety cannot call upon the creditor to invest him with all the rights which he had against the principal debtor. Invalid guarantee. The following are considered as invalid guarantee. Times guarantee obtained by misrepresentation. Section 142 provides that any guarantee which has been obtained by means of misrepresentation made by the creditor or with his knowledge and assent concerning a material part of the transaction is invalid. Times guarantee obtained by concealment. Section 143 provides that any guarantee within the creditor has obtained by means of keeping silence as to material circumstances is invalid. Examples. Times A engages B as clerk to collect money for him. B fails to account for some of his receipts, and A in consequence calls upon him to furnish security for his duly accounting. C gives his guarantee for B's duly accounting. A does not acquaint C with B's previous conduct. B afterwards makes default. The guarantee is invalid. Times A guarantees to C payment for iron to be supplied by him to B to the amount of 2,000 tons. B and C have privately agreed that B should pay 5 per ton beyond the market price, such excess to be applied in liquidation of an old debt. This agreement is concealed from A. A is not liable as surety. Co-surety. Section 144 provides that where a person gives a guarantee upon a contract, that the creditor shall not act upon it until another person has joined in it as co-surety. The guarantee is not valid if that other person does not join. Section 146 provides that the co-sureties are liable to contribute equally. This section provides that where two or more persons are co-sureties for the same debt or duty, either jointly or severally, and whether under the same or different contracts, and whether with or without the knowledge of each other, the co-sureties, in the absence of any contract to the contrary, are liable, as between themselves, to pay each an equal share of the whole debt, or of that part of it which remains unpaid by the principal debtor. Section 147 of the Act provides that co-sureties who are bound in different sums are liable to pay equally as far as the limits of their respective obligations permit. Examples. A, B and C, as sureties for D, enter into 3 several bonds, each in a different penalty, namely, A in the penalty of each 10,000 rupees, B in that of 20,000 rupees, C in that of 40,000 rupees, conditioned for D as duly accounting to E. D makes default to the extent of 30,000 rupees. A, B and C are each liable to pay 10,000 rupees. B, A, B and C, as sureties for D, enter into 3 several bonds, each in a different penalty, namely, A. In the penalty of 10,000 rupees, B. In that of 20,000 rupees, C. In that of 40,000 rupees, conditioned for DS duly accounting to E. D makes default to the extent of 40,000 rupees. A is liable to pay 10,000 rupees, and B and C 15,000 rupees each. The Institute of Cost Accountants of India. Laws and Ethics. 31. 31. C, A, B and C, as sureties for D, enter into 3 several bonds, each in a different penalty, namely, A in the penalty of 10,000 rupees, B in that of 20,000 rupees, C in that of 40,000 rupees, conditioned for DS duly accounting to E. D makes default to the extent of 70,000 rupees. A, B and C have to pay each the full penalty of his bond. Implied promise to indemnify surety. Section 145 provides that in every contract of guarantee there is an implied promise by the principal debtor to indemnify the surety, and the surety is entitled to recover from the principal debtor whatever sum he has rightfully paid under the guarantee, but no sums which he had paid wrongly. Examples: A. B is indebted to C, and A is surety for the debt. C demands payment from A, and on his refusal sues him for the amount. A defends the suit, having reasonable grounds for doing so, but is compelled to pay the amount of the debt, with costs. He can recover from B the amount paid by him for costs, as well as the principal debt. B. C lends B a sum of money, and A, at the request of B, accepts a bill of exchange drawn by B upon A to secure the amount. C. The holder of the bill demands payment of it from A and on A's refusal to pay, sues him upon the bill. A, not having reasonable grounds for so doing, defends the suit, and has to pay the amount of the bill and costs. He can recover from B and the amount of the bill, but not the sum paid for costs, as there was no real ground for defending the action. C. A guarantees to C, to the extent of 2,000 payment for rice to be supplied by C to B, C supplies to B rice to a less amount than 2,000, but obtains from a payment of the sum of 2,000 in respect of the rice supplied. A cannot recover from B more than the price of the rice actually supplied. Bailment and Pledge. Chapter 9 of the Act deals with bailment and pledge. Bailment. Section 148 defines the term bailment as the delivery of goods by one person to another for some purpose, upon a contract, that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. The bailment consists of times bailer, the person delivering the goods, is called the bailer, and times bailee, the person to whom the goods are delivered, is called the bailee. If a person, already in possession of the goods of other contracts to hold them as a bailee, he thereby becomes the bailee, and the owner becomes the bailer of such goods, although they may not have been delivered by way of bailment. The following are ingredients of the bailment. Times there must be a delivery of specific goods by one person to another. Times the delivery must be for some purpose. Times the delivery must be upon a contract, that the goods shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the bailer. Bailments may be classified into voluntary and involuntary. Voluntary bailments are the outcome of an express contract between the parties. Instances of involuntary bailments are found in cases of finders of good or of goods sent to a wrong place, or in excess of the quantity ordered, or in cases where the bailee dies and the subject of bailment comes into the hands of the bailee's heirs. Where there is no obligation to return the identical article, either in its original or in an altered form, there is no contract of bailment. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 32. Delivery to belly how made. Section 149 provides that the delivery to the belly may be made by doing anything which has the effect of putting the goods in the possession of the intended belly or any persons authorized to hold them on his behalf. Bailor's duty. Section 150 lays down three duties, namely, times it is the duty of the bailor to disclose to the belly faults in the goods bailed, of which the bailor is aware, and which materially interfere with the use of them, or expose the belly to extraordinary risks. Times if the bailor does not make such disclosure, and some loss or damage results, he is responsible for so much of it as arises to the belly directly from such faults. Times if the goods are bailed for hire, the bailor is responsible for damage arising to the belly directly from such faults, whether he was or was not aware of the existence of such faults in the goods bailed. Examples. Times a lends a horse, which he knows to be vicious, to B. He does not disclose the fact that the horse is vicious. The horse runs away. B is thrown and injured. A is responsible to B for damages sustained. Times A hires a carriage of B. The carriage is unsafe, though B is not aware of it, and A is injured. B is responsible to A for the injury. Care to be taken by belly. Section 151 provides that in all cases of bailment, the belly is bound to take as much care of the goods bailed to him as a man of ordinary prudence would, under similar circumstances, take of his own goods of the same bulk, quality, and value as the goods bailed. In Naglinga Chettiar v. Kairibana Chettiar, AIR 1915 Mad. 80, it was held that where the standard of care prescribed by Section 151 is not observed, the belly cannot be exonerated from his liability simply because the belly's goods were also lost along with the goods bailed. In Salmar Truck Operators Union v. National Insurance Co. Limited, AIR 2011, NOC 389, HP, it was held that the carrier cannot be exempted from its own negligence or negligence by his agent where goods carried at owner's risk, and cannot escape from the liability to make good loss. Belly when not liable. Section 152 provides that the belly, in the absence of any special contract, is not responsible for the loss, destruction or deterioration of the thing bailed, if he has taken the amount of care described in Section 151. Termination of bailment. Section 153 provides that a contract of bailment is voidable at the option of the bailor, if the belly does any act with regard to the goods bailed, inconsistent with the conditions of the bailment. Example, A lets to B, for hire, a horse for his own riding. B drives the horse in his carriage. This is at the option of A, a termination of the bailment. In Nikram v. Bank of Bengal, ILR 19 calories. 322 PV, it was held that this section is intended for the protection of the bailor whose goods are being used by the belly in a manner inconsistent with the conditions of the bailment. The bailor may put an end to the bailment although it was created for a specified purpose, which has not been accomplished, or for a prescribed, which has not expired. But merely exercising his rights irregularly by the belly, example, a sub-pledge or a premature sale by a pledge will not attract the application of the section. The Institute of Cost Accountants of India. Laws and Ethics. 33. Liability for unauthorized use of bailed goods. Section 154 provides that if the belly makes any use of goods bailed, which is not according to the conditions of the bailment, he is liable to make compensation to the bailor for any damage arising to the goods from or during such use of them. Example. A A lends a horse to be for his own riding only. B allows is, a member of his family, to ride the horse. C rides with care, but the horse accidentally falls and injured. B is liable to make compensation to A for the injury done to the horse. B. A hires a horse in Calcutta from B expressly to march to Banaras. A rides with due care but marches to Cuttack instead. The horse accidentally falls and is injured. A is liable to make compensation to B for the injury to the horse. In Hafizullah v. Montague, 165 I 354 it was held that where a car was entrusted to the defendant as a belly, and the evidence establishes that he was using the car for his private purposes in contravention of his agreement with the plaintiff, the bailer, it was held that the defendant was liable for the damages arising from such use. Mixing of the goods. The goods of the bailer may be mixed with the goods of the belly. This mixing may be done with or without the consent to the bailer. What would be the effect in such cases? Section 155 provides the solution for the same. This section provides that if the belly, with the consent of the bailer, mixes the goods of the bailer with his own goods, the bailer and the belly shall have an interest, in proportion to their respective shares, in the mixture thus produced. What would be the effect if the goods of the bailer are mixed with the goods of the belly without the consent of the bailer? Section 156 and 157 provide the solution for the same. Section 156 provides the effect of mixture without bailor's consent when the goods can be separated. Section 157 provides the effect of mixture without bailor's consent when the goods cannot be separated. Section 156 provides that if the belly, without the consent of the bailer, mixes the goods of the bailer with his own goods, and the goods can be separated or divided, the property in the goods remains in the parties, respectively, but the belly is bound to bear the expenses of separation or division, and any damage arising from the mixture. Example: a bales 100 bales of cotton marked with particular mark to be B, without A's consent, mixes the 100 bales with other bales of his own, bearing a different mark. A is entitled to have his 100 bales returned, and B is bound to bear all the expenses incurred in the separation of the bales and any other incidental damage. Section 157 provides that if the belly, without the consent of the bailer, mixed the goods of the bailer with his own goods, in such a manner that it is impossible to separate the goods bailed from the other goods, and deliver them back, the bailer is entitled to be compensated by the belly for the loss of the goods. Example: a bales a barrel of cap flour worth 45 to B without A's consent, mixes the flour with country flour of his own, worth only 25 a barrel. B must compensate A for the loss of his flour. Bailor's obligation. Section 158 and 164 impose obligation on the bailer. Section 158 provides that where, by the conditions of the bailment, the goods are to be kept or to be carried, or to have work done upon them by the Institute of Cost Accountants of India. Indian Contract Act, 1872. 34. Belly for the bailer and the belly is to receive no remuneration. The bailer shall repay to the belly the necessary expenses incurred by him for the purpose of the bailment. Section 164 provides that the bailer is responsible to the belly for any loss which the belly may sustain by reason that the bailer was not entitled to make the bailment, or to receive back the goods, or to give directions respecting them. Restoration of goods. The bailed goods should be returned after the bailment is over. Section 159 provides for the restoration of goods lent gratuitously and Section 160 provides for return of goods bailed on expiration of time or accomplishment of purpose. Section 161 provides for the responsibility of the bailee when goods are not duly returned. Section 159 provides that the lender of a thing for use may at any time require its return, if the loan was gratuitous, even though he lent it for a specified time or purpose. But if, on the faith of such loan made for a specified time or purpose, the borrower has acted in such a manner that the return of the thing lent before the time agreed upon would cause him loss exceeding the benefit actually derived by him from the loan, the lender must, if he compels the return, indemnify the borrower for the amount in which the loss so occasioned exceeds the benefit so derived. Section 160 provides that it is the duty of the bailee to return or deliver, according to the bailor's directions, the goods bailed without demand, as soon as the time for which they were bailed has expired, or for the purpose for which they were bailed has been accomplished. Non-delivery of the goods would amount to breach of contract. This section is silent as to the remedies open to a bailor when the bailee has failed to return the goods on his demand. In Dhyan Singh Shobha Singh v. Union of India, AIR 1958 SC 74, the Supreme Court held that a bailor, in the event of non-delivery of the goods by the bailee on demand made by him in that behalf, was entitled, at his election, to sue the bailee either for wrongful conversion of the goods or the wrongful detention thereof. Section 161 provides that if by default of the bailee, the goods are not returned, delivered, or tendered at the proper time, he is responsible to the bailor for any loss, destruction, or deterioration of the goods from that time. Section 163 provides that in the absence of any contract to the contrary, the bailee is bound to deliver to the bailor, or according to his directions, any increase or profit which may have accrued from the goods bailed. Example: A leaves a cow in the custody of B to be taken care of. The cow has a calf. B is bound to deliver the calf, as well as the cow, to A. Section 165 provides that if several joint owners of goods bail them, the bailee may deliver them back to, or according to the directions of, one joint owner without the consent of all, in the absence of any agreement to the contrary. Section 166 provides that if the bailor has no title to the goods, and the bailee, in good faith, delivers them back to, or according to the directions of, the bailor, the bailee is not responsible to the owner in respect of such delivery. Termination of gratuitous bailment by death. Section 162 provides that a gratuitous bailment is terminated by the death either of the bailor or of the bailee. Right of third person. Section 167 provides that if a person, other than the bailor, claims goods bailed, he may apply to the court to stop the delivery of the goods to the bailor and to decide the title to the goods. The Institute of Cost Accountants of India. Laws and Ethics. 35. Right of finder of goods. Section 168 provides that the finder of goods has no right to sue the owner for compensation for trouble and expense voluntarily incurred by him to preserve the goods and to find out the owner. But he may retain the goods against the owner until he receives such compensation, and, where the owner has offered a specific reward for the return of goods lost, the finder may sue for such reward, and may retain the goods until he receives it. Section 169 provides that when a thing which is commonly the subject of sale is lost, if the owner cannot, with reasonable diligence, be found, or if he refuses, upon demand, to pay the lawful charges of the finder may sell it. Times when the thing is in danger of perishing by or of losing the greater part of its value, or times when the lawful charges of the finder, in respect of the thing found, amount to 2/3 of its value. In MJR Steels, p. Limited v. Chrysomar Corporation, AIR 2007, NOC 234, call. It was held that it is not always necessary that sale should be by owner himself. Sale by agent or anyone with the consent of owner is valid. Finder of asset can also sale and give good title. There can also sale by estoppels. Bailey's lien. Section 170 provides that when the bailee has in accordance with the purpose of the bailment rendered any service involving the exercise of labor or skill in respect of the goods bailed, he has, in the absence of a contract, to the contrary, a right to retain such goods until he receives due remuneration for the service he has rendered in respect of them. Examples: A. Delivers a rough diamond to B, a jeweler, to be cut and polished, which is accordingly done. B is entitled to retain the stone till he is paid for the services he has rendered. B. Gives cloth to B, a tailor, to make into a coat. B promises A to deliver the coat as soon as it is finished, and to give a 3 months credit for the price. B is not entitled to retain the coat until he is paid. Pledge. Section 172 of the Act provides that the bailment of goods as security for payment of a debt or performance of a promise is called pledge. The pledge constitutes times pawner. The bailer in this case is called as pawner. Times pavni. The bailee in this case is called as pavni. A pledge is a bailment of movable property by way of security. The concept of pledge under this Act is dealt with under sections 172 to 179. In Maharashtra State Cooperative Bank Limited v. Assistant Provident Fund Commissioner, 2009, 10 SCC 123, it was held that in a pledge the pledge is in possession of and has a special property in the goods which he is entitled to detain to secure repayment. Unlike a mortgage, a pledge does not have the effect of transferring any interest in the property in favor of the pledge. Delivery of goods is necessary to complete a pledge. Difference between pledge and bailment. Section 172 of the Act define SA pledge to be the bailment of goods as security for payment of debt or performance of a promise, whereas Section 148 provides that a bailment is the delivery of goods by one person to another person for some purpose, upon a contract, that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the persons delivering them. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 36. Rights of Pavni. The rights of the Pavni are described in Section 173, 175 and 176. Section 173 provides that the Pavni may retain the goods pledged, not only for the payment of the debt or the performance of the promise, but for the interest of the debt, and all necessary expenses incurred by him in respect of the possession or for the preservation of the goods pledged. Section 175 provides that the Pavni is entitled to receive from the pawner extraordinary expenses incurred by him for the preservation of the goods pledged. Section 176 provides that if the pawner makes default in payment of the debt or performance at the stipulated time of the promise, in respect of which the goods were pledged, the Pavni may bring a suit against the pawner upon the debt or promise and retain the goods pledged as a collateral security, or he may sell the things pledged on giving the pawner a reasonable notice of the sale. If the proceeds of such sale are less than the amount due in respect of the debt or promise, the pawner is still liable to pay the balance. If the proceeds of the sale are greater than the amounts so due, the Pavni shall pay over the surplus to the pawner. Retaining of the goods by Pavni. Section 174 provides that the Pavni shall not, in the absence of a contract to that effect, retain the goods pledged for any debt or promise other than the debt or promise for which they are pledged. But such contract, in the absence of anything to the contrary, shall be presumed in regard to subsequent advances made by the Pavni. Pledge by mercantile agent. Section 178 provides that where a mercantile agent is, with the consent of the owner, in possession or goods or the documents of the title of goods, any pledge made by him, when acting in the ordinary course of business of a mercantile agent, shall be as valid as if he were expressly authorized by the owner of the goods to make the same, provided the Pavni acts in good faith and has not at the time of the pledge notice that the pawnee has no authority to pledge. The term mercantile agent is defined under Section 2 of Sale of Goods Act as an agent having in the course of ordinary business having authority, either to sell goods or to consign goods for the purposes of sale or to buy goods or to raise money on the security of the money. Pledge in a voidable contract. Section 178 provides that when the pawnee has obtained possession of the goods pledged by him under a contract voidable under Section 19 or Section 19A, but the contract has not been rescinded at the time of pledge, the Pavni acquires a good title to the goods, provided he acts in good faith and without notice of the pawnee's defect of title. Limited interest of pawnee. Section 179 provides that where a person pledges goods, in which he has only a limited interest, the pledge is valid to the extent of that interest. Suit against wrongdoers. Section 180 provides that if a third person wrongfully deprives the bailee of the use of possession of the goods bailed, or does them any injury, the bailee is entitled to use such remedies as the owner might have used in the like case if no bailment had been made, and either the bailer or the bailee may bring a suit against a third person for such deprivation or injury. Apportionment of relief. Section 181 provides that whatever is obtained by way of relief or compensation in any such suit shall, as between the bailer and bailee, be dealt with according to their respective interests. The Institute of Cost Accountants of India. Laws and Ethics. 37. Agency Chapter X of the Act deals with agency. Section 182 provides that an agent is a person employed to do any act for another or to represent another in dealing with the third person. Principal, the person for whom such act is done, or who is so represented, is called the principal. Provisions regarding to agent times. A person may become an agent times if he is of the age of majority according to the law to which he is subject, times he is of sound mind, times no consideration is necessary for the appointment of agent, times the authority of an agent may be expressed or implied. Section 187 defines the terms expressed authority and implied authority. An authority is said to be express when it is given by words spoken or written. An authority is said to be implied when it is to be inferred from the circumstances of the case, and things spoken or written, or the ordinary course of dealing, may be accounted circumstances of the case. Example: A owns a shop in Sirpur, himself living in Calcutta, and visiting the shop occasionally. The shop is managed by B, and he is in the habit of ordering goods from C in the name of A for the purposes of the shop, and of paying for them out of A's funds with A's knowledge. B has an implied authority from A to order goods from C in the name of A for purposes of the shop. Section 184 provides that as between the principal and third persons, any person may become agent, but no person who is not of the age of the majority and of sound mind can become an agent, so as to be responsible to his principal according to the provisions in that behalf. Section 185 provides that no consideration is necessary to create an agency. Section 188 provides that an agent having an authority to do an act has authority to do every lawful thing which is necessary in order to do such act. An agent having an authority to carry on a business has authority to do every lawful thing necessary for the purpose, or usually done in the course of conducting such business. Examples: A. A is employed by B, residing in London to recover at Bombay a debt due to B. A may adopt any legal process necessary for the purpose of recovering the debt, and may give a valid discharge for the same. B. A constitutes B his agent to carry on his business of a shipbuilder. B may purchase timber and other materials and hire workmen for the purposes of carrying on his business. Section 189 provides the agent's authority in an emergency. According to this section, an agent has authority in an emergency to do all such acts for the purpose of protecting his principal from loss as would be done by a person of ordinary prudence, in his own case, under similar circumstances. Examples: an agent for sale may have goods repaired if it be necessary. B. A consigns provisions to be at Calcutta, with direction to send them immediately to sea at Cuttack. B may sell the provisions at Calcutta, if they will not bear the journey to Cuttack without spoiling. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 38. Section 190 provides that when agent cannot delegate his authority, an agent cannot lawfully employ another to perform acts which he has expressly or impliedly undertaken to perform personally, unless by the ordinary custom of a trade a subagent may, or from the nature of the agency, a subagent must, be employed. Sub-agent. Section 191 defines the term subagent as a person employed by and acting under the control of the original agent in the business of the agency. Section 192 provides that where a sub-agent is properly appointed, the principal is, so far as regard third persons, represented by the sub-agent, and is bound by and responsible for his acts, as if he were an agent originally appointed by the principal. The agent is responsible to the principal for the acts of the sub-agent. The sub-agent is responsible for his acts to the agent, but not to the principal except in cases of fraud or willful wrong. Section 193 provides for the responsibility of the agent for sub-agent appointed without authority. Where an agent, without having authority to do so, has appointed a person to act as a subagent, the agent stands towards such person in the relation of a principal to an agent, and is responsible for his acts both to the principal and to third persons. The principal is not represented by, or responsible for, the acts of the person so employed, nor is that person responsible to the principal. Section 194 provides that where an agent, holding an express or implied authority to name another person to act for the principal in the business of the agency, has named another person accordingly, such person is not a subagent, but an agent of the principal for such part of the business of the agency as is entrusted to him. Examples: A. Directs B, his solicitor, to sell his estate by auction, and to employ an auctioneer for the purpose. B names C, an auctioneer, to conduct the sale. C is not a subagent, but A's agent for the conduct of the sale. B. A authorizes B, a merchant in Calcutta, to recover the money due to A from C and Co. B instructs D, a solicitor, to take legal proceedings against C and Co. for the recovery of the money. D is not a subagent, but is a solicitor for A. Agent's duty. Section 195 provides that in selecting such agent for his principal, an agent is bound to exercise the same amount of discretion as a man of ordinary prudence would exercise in his own case, and if he does this, he is not responsible to the principal for the acts or negligence of the agent so selected. Example: A instructs B, a merchant, to buy a ship for him. B employs a ship surveyor of good reputation to choose a ship for A. The surveyor makes the choice negligently, and the ship turns out to be unseaworthy and is lost. B is not, but the surveyor is responsible to A. B consigns goods to B, a merchant, for sale. B, in due course, employs an auctioneer in good credit to sell the goods of A and allows the auctioneer to receive the proceeds of the sale. The auctioneer afterwards becomes insolvent without having accounted for the proceeds. B is not responsible to A for the proceeds. Ratification. Section 196 provides for right of person as to acts done for him without his authority. Where acts are done by one person on behalf of another, but without his knowledge or authority, he may elect to ratify or to disown such acts. If he ratifies them, the same effects will follow as if they had been performed by this authority. The Institute of Cost Accountants of India. Laws and Ethics. 39. Section 197 provides that the ratification may be expressed or implied in the conduct of the person on whose behalf the acts are done. Examples: A, without the authority, buys goods for B, afterwards B sells them to C on his own account. B's conduct implies a ratification on the purchase made for him by A. B, without B's authority, lends B's money to C, afterwards B accepts interest on the money from C. B's conduct implies a ratification of the loan. Section 198 provides that no valid ratification can be made by a person whose knowledge of the facts of the case is materially defective. Section 199 prescribes the effect of ratifying any unauthorized act forming part of a transaction. A person ratifying any unauthorized act done on his behalf ratifies the whole of the transaction of which such act formed a part. Section 200 provides that ratification of unauthorized act cannot injure third person. An act done by one person on behalf of another, without such other person's authority, would have the effect of subjecting a third person to damages, or of terminating any right or interest which, if done with authority of a third person, cannot, by ratification, be made to have such effect. Example: A, not being authorized thereto by B, demands on behalf of B the delivery of a chattel, the property of B, from C, who is in possession of it. This demand cannot be ratified by B, so as to make C liable for damages for his refusal to deliver. B holds a lease from B, terminable on 3 months' notice. C, an unauthorized person, gives notice of termination to A. The notice cannot be ratified by B, so as to be binding on A. Termination of agency. Section 201 provides for the termination of agency. An agency is terminated by the principal times revoking his authority, or times by the agent renouncing the business of the agency, or times by the business of the agency being completed, or times by either the principal or agent dying or becoming of unsound mind, or times by the principal being adjudicated and insolvent under the provisions of any act for the time being. In force for the relief of insolvent debtors. Section 202 provides that where the agent has himself an interest in the property which forms the subject matter of the agency cannot, in the absence of an express contract, be terminated to the prejudice of such interest. Examples: A gives authority to B to sell A's land and to pay himself, out of the proceeds, the debts due to him. A cannot revoke his authority, nor can it be terminated by his insanity or death. B A consigns 1,000 bales of cotton to B, who has made advances to him on such cotton, and desires B to sell the cotton, and to repay himself out the price, the amount of his own advances. A cannot revoke the authority nor is it terminated by his insanity or death. Section 208 provides, as to the time at which the agent's authority is terminated as to agent and as to third persons. The termination of the authority of an agent does not, so far as regards the agent, take effect before it becomes known to him, or, so far as regards third persons, before it becomes known to them. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 40. Example. A. A directs B to sell goods for him and agrees to give B 5% commission on the price fetched by the goods. A afterwards, by letter, revokes B's authority. B, after the letter is sent, but before he receives it, sells the goods for 100 dash. The sale is binding on A and is entitled to 5 as his commission. B. A, at Madras, by letter directs B to sell for him some cotton lying in a warehouse in Bombay and afterwards, by letter, revokes his authority to sell and directs B to send the cotton to Madras. B, after receiving the second letter, enters into a contract with C, who knows the first letter, but not of the second, for the sale to him of the cotton. C pays B the money, with which B absconds. C's payment is good as against A. C. A directs B, his agent, to pay certain money to C. A dies and D takes out probate to his will. B, after A's death, but before hearing of it, pays the money to C. The payment is good as against D, the executor. Revocation of agent's authority. Section 203 provides for the revocation of agent's authority. The principal may, save as is otherwise provided by Section 202, revoke the authority given to his agent at any time before the authority has been exercised so as to bind the principal. Section 204 provides that the principal cannot revoke the authority given to his agent after the authority has been partly exercised, so far as regards such acts and obligations as arise from acts already done in the agency. Examples. A authorizes B to buy 1,000 bales of cotton on account of A, and to pay for it out of A's monies remaining in B's hands. B buys 1,000 bales of cotton in his own name, so as to make himself personally liable for the price. A cannot revoke B's authority so far as regards payment for the cotton. B. A authorizes B to buy 1,000 bales of cotton on account of A, and to pay for it out of A's monies remaining in B's hands. B buys 1,000 bales of cotton in A's name, and so as not to render himself personally liable for the price. A can revoke B's authority to pay for the cotton. Compensation. Section 205 provides for the provision of compensation for revocation by principal or renunciation by agent. When there is an express or implied contract that the agency should be continued for any period of time, the principal must make compensation to the agent, or the agent to the principal, as the case may be, for any previous revocation or renunciation of the agency without sufficient cause. Notice of revocation. Section 206 provides that reasonable notice must be given before revocation or renunciation of the agency. Otherwise, the damage thereby resulting to the principal or the agent, as the case may be, must be made good to the one by the other. Section 207 provides that revocation and renunciation may be expressed or implied in the conduct of the principal or agent respectively. Example. A empowers B to let A's house. Afterwards, A lets it himself. This is an implied revocation of B's authority. Agent's duty on termination of agency. Section 209 provides that when an agency is terminated by the principal dying or becoming of unsound mind, the agent is bound to take, on behalf of the representatives of his late principal, all reasonable steps for the protection and preservation of interests entrusted to him. The Institute of Cost Accountants of India. Laws and Ethics. 41. 41. Termination of subagent's authority. Section 210 provides that the termination of the authority of an agent causes the termination of the authority of all sub-agents appointed by him. Agent's duty. Times Section 211 provides that an agent is bound to conduct the business of his principal according to the directions given by the principal, or in the absence of any such directions, according to the custom which prevails in doing business of the same kind at the place where the agent conducts such business. When the agent acts otherwise, if any loss be sustained, he must make it good to his principal, and if any profit accrues, he must account for it. Examples. A. An agent engaged in carrying on for B a business, in which it is the customs to invest from time to time, at interest, the monies which may be in hand, amidst to make such investment. A must make good to B the interest usually obtained by such investments. B. A broker in whose business it is not the custom to sell on credit, sell goods of A on credit to C, whose credit at the time was very high. C, before payment, becomes insolvent. B must make good the loss to A. Times Section 212 provides that an agent is bound to conduct the business of the agency with as much skill as is generally possessed by persons engaged in similar business unless the principal has notice of his want of skill. The agent is always bound to act with reasonable diligence and to use such skill as he possesses, and to make compensation to his principal in respect of the direct consequences of his own neglect, want of skill, or misconduct, but not in respect of loss or damage which are indirectly or remotely caused by such neglect, want of skill or misconduct. Examples. A merchant in Calcutta has an agent, B in London, to whom a sum of money is paid on A's account, with orders to remit. B retains the money for a consideration time. A, in consequence of not receiving the money, becomes insolvent. B is liable for the money and interest from the day on which it ought to have been paid, according to the usual rate, and any further direct loss, as example, by variation of rate of exchange, but not further. B. An agent for the sale of goods, having authority to sell on credit, sells to B on credit, without making the proper and usual enquiries as to the solvency of B. B at the time of such sale is insolvent. A must make compensation to his principal in respect of any loss thereby sustained. C. An insurance broker employed by B to effect an insurance on a ship, omits to see that the usual clauses are inserted in the policy. The ship is afterwards lost. In consequence of the omission of the clauses, nothing can be recovered from the underwriters. A is bound to make good the loss to B. D. A merchant in England directs B, his agent at Bombay, who accepts the agency, to send him 100 bales of cotton by a certain ship. B, having it in his power to send the cotton, omits to do so. The ship arrives safely in England. Soon after her arrival, the price of cotton rises. B is bound to make good to A the profit, which he might have made by the 100 bales of cotton at the time the ship arrived, but not any profit he might have made by the subsequent rise. Times Section 213 provides that an agent is bound to render proper accounts to his principal on demand. Times Section 214 provides that it is the duty of an agent, in cases of difficulty, to use all reasonable diligence in communicating with his principal and in seeking to obtain his instructions. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 42. Right of principal. The rights of principal are described in sections 215 and 216. Times Section 215 provides that if an agent deals on his own account in the business of the agency, without first obtaining the consent of the principal and acquainting him with all material circumstances which have come to his own knowledge on the subject, the principal may repudiate the transaction, if the case shows either that any material fact has been dishonestly concealed from him by the agent, or that the dealings of the agent have been disadvantageous to him. Examples: A. Directs B to sell A's estate. B buys the estate for himself in the name of C. A, on discovering that B has bought the estate for himself, may repudiate the sale if he can show that B has dishonestly concealed any material act, or that the sale has been disadvantageous to him. B. Directs B to sell A's estate. B, on looking over the estate before selling it, finds a mine on the estate which is unknown to A. B informs A that he wishes to buy the estate for himself, but conceals the discovery of the mine. A allows B to buy, in ignorance of the existence of the mine. A, on discovering that B knew of the mine at the time he bought the estate, may either repudiate or adopt the sale at his option. Times Section 216 provides that if an agent, without the knowledge of his principal, deals in the business of the agency on his own account instead of on account of his principal, the principal is entitled to claim from the agent any benefit which may have resulted to him from the transaction. Example: A direct B, his agent, to buy a certain house for him. B tells A that it cannot be bought, and buys the house for himself. A may, on discovering that B has bought the house, compel him to sell it to A at the price he gave for it. Agent's right. The rights of agents are prescribed in Section 217 and 219. Times Section 217 provides that an agent may retain, out of any sums received on account of the principal in the business of the agency, all monies due to himself in respect of advances made or expenses properly incurred by him in conducting such business, and also such remuneration as may be payable to him for acting as agent. Times Section 218 provides that subject to such deductions, the agent is bound to pay to his principal all sums received on his account. Times Section 219 provides that in the absence of any special contract, payment for the performance of any act is not due to the agent until the completion of such act, but an agent may detain monies received by him on account of goods sold, although the whole of the goods consigned to him for sale may not have been sold, or although the sale may not be actually complete. Misconduct of agent. Section 220 provides that an agent, who is guilty of misconduct in the business of the agency, is not entitled to any remuneration in respect of that part of the business which he has been misconducted. Examples: A employs B to recover 1 lakh from C and to lay it out on good security. B recovers 1 lakh and lays out 90,000 on good security, but lays out 10,000 on security which he ought to have known to be bad, whereby A loses 2,000 B is entitled to remuneration for recovering 1,000,000 and for investing 90,000. He is not entitled to any remuneration for investing 10,000 and he must make good the 2,002 A. B employs B to recover 1 000 from C. Through B's misconduct, the money is not recovered. B is entitled to no remuneration for his services and must make good the loss. The Institute of Cost Accountants of India. Laws and Ethics. 43. Agents Lien. Section 221 provides that in the absence of any contract to the contrary, an agent is entitled to retain goods, papers, and other property, whether movable or immovable, of the principal received by him, until the amount due to himself for commission, disbursements, and services in respect of the same has been paid or account for to him. Obligation of principal to agent. Times Section 222 provides that the employer of an agent is bound to indemnify him against the consequences of all lawful acts done by such agents in exercise of the authority conferred upon him. Examples: A. B. at Singapore, under instructions from A of Calcutta, contracts with C to deliver certain goods to him. A does not send the goods to B, and C sues B for breach of contract. B informs A of the suit, and A authorizes him to defend the suit. B defends the suit and is compelled to pay damages and costs and incur expenses. A is liable to B for such damages, costs, and expenses. B. A broker at Calcutta, by the orders of A, a merchant there, contracts with C for the purpose of 10 casks of oil for A, afterwards A refuses to receive the oil and C sues B. B informs A, who repudiates the contract altogether. B defends, but unsuccessfully, and has to pay damages and costs and incur expenses. A is liable to B for such damages, costs, and expenses. Times Section 223 provides that where one person employs another to do an act, and the agent does the act in good faith, the employer is liable to indemnify the agent against the consequences of that act, though it causes an injury to the rights of third persons. Examples: A. A decree holder and entitled to execution of B's goods requires the officer of the court to seize certain goods, representing them to be the goods of B. The officer seizes the goods and is sued by C, the true owner of the goods. A is liable to indemnify the officer for the sum which he is compelled to pay to C in consequence of obeying A's directions. B. At the request of A, sells goods in the possession of A, but which A had no right to dispose of. B does not know this and hands over the proceeds of the sale to A. Afterwards C, the true owner of the goods, sues B and recovers the value of the goods and costs. A is liable to indemnify B for what he has been compelled to pay to C and for B's own expenses. Times Section 225 provides that the principal must make compensation to his agent in respect of injury caused to such agent by the principal's neglect or want of skill. Example: A employs B as a bricklayer in building a house and puts up the scaffolding himself. The scaffolding is unskillfully put up, and B is in consequence hurt. A must make compensation to B. Non-liability of principal to agent. Section 224 provides that where one person employs another to do an act which is criminal, the employer is not liable to the agent, either upon an express or implied promise to indemnify him against the consequences of that act. Example: A employs B to beat C and agrees to indemnify him against all consequences of the act. B thereupon beats C and has to pay damages to C for so doing. A is not liable to indemnify B for those losses. B. The proprietor of a newspaper publishes, at A's request, a libel upon C in the paper, and A agrees to indemnify B against the consequences of the publication and all costs and damages of any action in respect thereof. B is sued by C and has to pay damages and also incurs expenses. A is not liable to be upon the indemnity. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 44. Agency with third persons. Section 226 provides for the enforcement and consequences of agents' contracts. Contracts entered into through an agent and obligations arising from acts done by an agent may be enforced in the same manner and will have the same legal consequences as if the contracts had been entered into and the acts done by the principal in person. Examples: A buys goods from B, knowing that he is an agent for their sale, but not knowing who is the principal. B's principal is the person entitled to claim from A the price of the goods, and A cannot, in a suit by the principal, set off against that claim a debt due to himself from B. A, being B's agent, with authority to receive money on his behalf, receives from C a sum of money due to B. C is discharged of his obligation to pay the sum in question to B. Section 227 provides that when an agent does more than he is authorized to do, and when the part of what he does, which is within his authority, can be separated from the part which is beyond his authority, so much only of what he does as is within his authority is binding as between him and his principal. Example: A being owner of a ship and cargo, authorize B to procure an insurance for 4,000 on the ship. B procures a policy for 4,000 on the ship and another for the like sum on the cargo. A is bound to pay the premium for the policy on the ship, but not the premium for the policy on the cargo. Section 228 provides that principal is not bound when excess of agent's authority is not separable. Where an agent does more than he is authorized to do, and what he does beyond the scope of his authority cannot be separated from what is within it, the principal is not bound to recognize the transaction. Example: A authorizes B to buy 500 sheep for him. B buys 500 sheep and 200 lambs for one sum of 6,000. A may repudiate the whole transaction. Notice to agent. Section 229 provides that any notice given to or information obtained by the agent, provided it be given or obtained in the course of the business transacted by him for the principal, shall, as between the principal and third parties, have the same legal consequences as if it had been given to or obtained by the principal. Examples: A is employed by B to buy from C certain goods, of which C is the apparent owner, and buys them accordingly. In the course of the treaty for the sale, A learns that the goods really belong to D, but B is ignorant of that fact. B is not entitled to set off a debt owing to him from C against the price of the goods. A is employed by B to buy from C goods of which C is the apparent owner. A was, before he was so employed, a servant of C, and then learnt that the goods really belong to D, but B is ignorant of that fact. In spite of the knowledge of his agent, B may set off against the price of the goods a debt owing to him from C. Enforcement of contract by agent on behalf of principal. Section 230 provides that in the absence of any contract to that effect, an agent cannot personally enforce contracts entered into by him on behalf of his principal, nor is he personally bound by him. Such a contract shall be presumed to exist in the following cases. 1. Where the contract is made by an agent for the sale or purchase of goods for a merchant resident abroad. 2. Where the agent does not disclose the name of his principal. 3. Where the principal, though disclosed, cannot be sued. The Institute of Cost Accountants of India. Laws and ethics. 45. Right of parties to a contract made by agent. Section 231 provides the right of parties to a contract made by agent not disclosed. If an agent makes a contract with person who neither knows nor has reason to suspect that he is an agent, his principal may require the performance of the contract, but the other contracting party has, as against the principal, the same rights as he would have had as against the agent if the agent had been principal. If the principal discloses himself before the contract is completed, the other contracting party may refuse to fulfill the contract. If he can show that, if he had known who was the principal in the contract, or if he had known that the agent was not a principal, he would not have entered into the contract. Section 232 provides that where one man makes a contract with another, neither he knowing nor having reasonable ground to suspect that the other is an agent, the principal, if he requires the performance of the contract, can only obtain such performance subject to the rights and obligations subsisting between the agent and the other party to the contract. Example: A, who owes 500 to B, sells 1000 worth of rice to B. A is acting as agent for C in the transaction, but B has neither knowledge nor reasonable ground of suspicion that such is the case. C cannot compel B to take the rice without allowing him to set off A's debt. Section 233 provides that in cases where the agent is personally liable, a person dealing with him may hold either him or his principal, or both of them liable. Example: A enters into a contract with B to sell him 100 bales of cotton and afterwards discovers that B was acting as agent for C. A may sue either B or C, or both, for the price of the cotton. Section 234 provides that when a person who has made a contract with an agent induces the agent to act upon the belief that the principal only will be held liable, or induces the principal to act upon the belief that the agent only will be held liable, he cannot afterward hold liable the agent or principal respectively. Liability of a pretended agent. Section 235 provides that a person untruly representing himself to be the authorized agent of another, and thereby inducing a third person to deal with him as such agent, is liable, if his alleged employer does not ratify his acts, to make compensation to the other in respect of any loss or damage which he has incurred by so dealing. Section 236 provides that a person with whom a contract has been entered into in the character of agent is not entitled to require the performance of it, if he was in reality acting not as agent, but on his account. Section 237 provides that when an agent has, without authority, done acts or incurred obligations to third persons on behalf of his principal, the principal is bound by such acts of obligations, if he has by his words or conduct induced such third persons to believe that such acts and obligations were within the scope of the agent's authority. Example: A consigns goods for B for sale and gives him instructions not to sell under a fixed price. C, being ignorant of B's instructions, enters into a contract with B to buy the goods at a price lower than the reserve price. A is bound by the contract. B entrusts B with negotiable instruments in blank. B sells them to C in violation of private orders from A. The sale is good. Effect of misrepresentation or fraud by agent. Section 238 provides that misrepresentation made or frauds committed by agents acting in the course of their business for their principals have the same effect on agreements made by such agents as if some misrepresentations or frauds had been made or committed by the principals, but misrepresentations made or frauds committed by agents in matters which do not fall within their authority, do not affect their principles. The Institute of Cost Accountants of India. Indian Contract Act, 1872. 46. Examples: A. Being B's agent to the sale of goods, induces C to buy them by a misrepresentation, which he was not authorized by B to make. The contract is voidable, as between B and C, at the option of C. B. The captain of B's ship signs bills of lading without having received on board the goods mentioned therein. The bills of lading are void, as between B and pretended consignor. Check